Maintenance.
my lord, maintenance.
You pay maintenance. Your wife only you are paying.
She is capable and she is earning more, my lord, and I am jobless, my lord.
After marrying, you become jobless or
My lord.
anyway, you give it.
Lordship, this matter is related to questioning of affair.
What is the urgency passing of it?
I'm mentioning
These on, let them do it. Give it, let us.
Yes, I'm mentioning the memo.
Pardon, my lord. I do not 54, 58 urgent, my lord, 1 week, my lord.
54. After notice or fresh matter?
Yes, matter.
Fresh matter.
54, 55, my lord.
54.
54 or 55?
54 and 55. Just the after notice or fresh matter? After notice. Or the after notice, then come at the time. The other side is objective.
Sir, health is, sir, my senior is health, so severe health
Not
is.
that I noted down, I'll adjourn it, but still you have to be there.
Yes, sir.
I'll adjourn it, no problem.
Yes.
I have another prayer, my lord. Item 48, my lord. We will file a joint affidavit, my lord. Next week, as soon as that.
Settle.
Yeah, settle.
48. Joint they will file. Then consequent the petition submits that they would be filing, the matter is already settled. They would be filing a joint affidavit. The parties would file joint affidavits. And the parties would also present it to court in the next day. Next.
Pardon, I can mention your lordship. Lordship is a fair service on questioning of DB proceeding, your lordship. The petitioner are the father and mother. Fair submission.
On behalf of Mr. P.K. Jana, fresh admission, my lord.
Pardon to mention, my lord, item number 15 on behalf of Udit Ranjan Jana, kindly adjourn this matter. 19
50.
15 15.
15.
Yes.
You wait, you watch the proceeding till 15. Within 1 hour, within less than half an hour, you will do. Do you have any appointment somewhere? Do you have any work?
He is busy. We'll go to another court.
Okay, fresh matter. Leave it. Yes.
Adjourn this matter on 19 February.
You don't select the date. Let the court select. Okay, you want an adjournment? You got it.
Okay, my lord.
Selection of date will be done by our registry. Okay. You got an opportunity, you should have argued. You lost that opportunity. Then whenever it suits, then it will come. What to do? Item 1. Yes. 1.
It's challenging the order dated 19/4/2023, where the plaint has been rejected on the ground that the petition has not adduced his evidence, my lord. Although it was mentioned that the number of occasions he has taken time to adduce evidence, my lord, conducting counsel has not intimated to the petitioner with regard to lordship. Paragraph 80 I have reflected in my petition.
Say, which is the order you are challenging?
19/4/2014.
What happened?
Annexure 2, my lord.
What happened?
The plaint has been rejected. Complaint case has been rejected. The matter arranging out to pay 130 in act.
You are the complainant.
Yes.
You issue notice to the opposite party number 2, returnable within 2 weeks.
Okay.
What is the check amount?
35,000.
35,000. Yes. Yes. Item 2. 2, pass out.
2 May state case, my
lord. State case. Okay.
There are 2 cases, my lord.
Yes. 2 and 3.
No, my lord.
Not 2 only, there are 2. Some items. Huh?
2, there are 2 cases.
Okay. What is this case about?
This case, my lord,
Hmm.
the forest authority, my lord, seized the vehicle, my lord, of the opposite party number 2, my lord. Opposite party, my lord, and simultaneously, my lord, the seizure made to the front court below, and subsequently, the OP filed an application under section 457 CRPC for release of the vehicle, my lord.
Yes.
Accordingly, that has been released in favor of the opposite party, my lord. And thereafter, the petitioner, my lord, filed the case before the sessions for criminal revision, my lord. And that has also been confirmed. Against that, the petitioner filed this application before the
457 with security.
Since, my lord, the vehicle in question involved in forest offences, my lord. And for that reason, my lord, when the confessional proceeding already started, my lord, the court should have rejected the application for petition instead of my lord, allowing the application and directing the release.
What is the next second sub item?
Same case, another vehicle, my lord. Same first particular, my lord.
I am
This-
appearing,
You are appearing,
I am appearing in 644,
the sub item,
644 of 2023.
first one.
I have submitted a note, your lordship may kindly see.
No, the only question is, if there is a confiscation proceeding,
No. Your lordship will see kindly see the order of the SDGM.
That has been made.
That has never, that has not begun.
No, my lord, already started. Confiscation
Yes,
already started, my lord.
yes, your lordship may kindly see.
so
And a notice also issued to the
Notice
opposite
may have
party.
been issued, but no confiscation proceeding was on the day the learned SDGM passed the order.
but thereafter, when the revision was pending, by that time
Madam.
it is all.
Maybe,
Madam.
but what the regional authority will do? He will see whether the order passed by the SDGM is correct or not
That's
on the
right.
materials placed before him. That he has done. And besides, there are other points. Your lordship may kindly see my note, ma'am.
Note, huh?
This is my note. I am placing, madam. It is not maintainable in the present form in as much as the DFO Kalahandi North Division cannot represent the state of Orissa. Besides, the order impugned as at Annexure 7 to the CRLMC petition, the DFO was not a party. However, otherwise also the petition is not maintainable in as much as the revisional court in deciding the revision petition filed under section 397 CRPC has not committed any wrong. Ground A advanced by the petitioner is not supported by any concrete material, as has been noted by the learned session judge in his order under Annexure 7. By the time the learned STGM Bhavanipatna passed the order dated 8/4/22, no confiscation proceeding had been initiated, which is evident from the order dated 8/4/22. The
What
learned
happened to confiscation proceeding?
Madam, confiscation proceeding pending, my lord,
Hmm.
and stay has been, that has not been proceeded, my lord. Since vehicle released in favor of the opposite
Oh,
party.
he might have given a indemnity bond.
Yes,
No, no,
If
not,
you
not, not,
your lordship may kindly
Not-
look.
not-
Where is that order?
Your lordship may
I
kindly.
will, see, I'll add a condition
my lord.
that let him file
Your
give a
lordship-
indemnity bond. And the
Your-
moment confiscation
Your
proceeding
lordship may
succeeds,
kindly,
he has to give it.
Again, there is one, your lordship may kindly look at page 42.
What it?
The grounds on which the
Let us
conditions,
see.
the conditions set by the learned SDGM, this is there
Yes. Where is that, sir?
at page 42,
42.
last part.
Last one.
These conditions have been set.
Condition imposed, but in fact, the vehicle has not
See,
been
if
released, my lord.
you proceed with the confiscation.
But the
proceeding.
initial, my lord, when the my lord, forest product, my lord, seized from the vehicle, my lord, the magistrate has no power to release the vehicle, my lord.
No, the moment the
My
confiscation.
magistrate should have called for a report from the, my lord, the
That day it
police
was not
officer, whether the
initiated.
confession proceeding, they are
That
not,
day-
my lord.
That day it was not initiated. That's what the case is. Now, what is the prejudice to you? If
Madam,
he succeed in confiscation proceeding,
Madam,
My lord,
he has given the
Yes.
indemnity,
And-
he has to give it back.
enough grounds are there to ensure that the property is placed before the authorized officer as and when if it is directed.
no, my lord, the forest
Yeah.
product, my lord, section 52, see, my lord, straightway, my lord, denied the release of the vehicle, my lord. Section is very clear, my lord, for that, I have given 2 decisions of this on report, my
Now, section 52, you have initiated then only, na?
My lord.
The day when
Yes.
the order was passed.
We have challenged, my lord, in the revision, my lord. So, since the confiscation was already started, my lord, we have refer revision, my lord. My lord,
Revision,
given, my lord.
even the revision petition is not maintainable. Your lordship may kindly turn to page 48.
Where is the
First
berek?
edit.
I told you to get a berek. You are giving such a big thing. Get the berek from my
There more than
chamber.
voyage.
Send them on. Now, what are the conditions?
Yes, इतना कैसे लगा?
Where is your objection to in the one?
That they have not produced.
And Lord Court will relying to decision of the Hon'Ble one appeals court, another repetition of this Hon'Ble court, my lord, and granted the,
No, in the case of this condition, I don't think you require it. Let's see the condition.
my lord.
Page 42. First condition is petitioner will produce the seized vehicle as and when required by the court. If your confiscation proceedings start, you confiscate.
By the court, my lord.
He
When that
will
when
have
by
to,
the
he has
court,
to
my lord.
produce it. What is
My
the big deal about it?
That is, my lord,
Everything has been given, my lord.
Yeah,
when law is not permitting, my lord, the religious vehicle, my lord, when
that's,
the
you are right.
products
I'm
is, my
not
lord.
on that. You are right.
My lord, for that reason, my lord.
The day when the order was passed, that time it was not initiated. That's the old. What are the judgment?
My lord, I have given to this soft copy, my lord. One reported in live, no, another is, my lord, that's that. My state, my lord, the honorable Appeals Court, my lord, and also the Madhya Pradesh High Court, my lord. Not permitted. When that has been seized, my lord, magistrate has no power, absolute, my lord. When the magistrate came to know that the vehicle involved in Forest Act, my lord, magistrate should have called for a report, my
Which
lord.
provision you are saying?
52, my lord.
52. Yes,
6, my lord.
on 52.
6.
52?
56, my lord.
56. Yes, yes.
See, my
Yes.
lord.
When the trial of any forest offense is concluded, any forest produce in respect of which the offense has been committed, shall, if it is a property, it is after conclusion, this is what? 56, just see.
My lord.
Disposal on the, after the conclusion,
My lord.
doesn't bar anything.
And that out, my lord. Also, my lord,
Which provision? Show me the judgment, which judgment you are, where is that judgment?
one respected life, my lord, another is.
No, where is it?
No, no. See, sufficient.
My lord, on High Court of Madhya Pradesh, my lord, judgment, my lord, in the WP number 186 for 604 2021, my lord. There, my lord, the
Where
primary learned government advocate appearing for the respondent, my lord, read out second paragraph, my lord. State points out that in view of the law laid down by the Supreme Court in the state of Madhya Pradesh versus Uday Singh 2020 12 SEC page 733 and various other similar cases. Once the vehicle is confiscated under the Forest Act,
which one you are reading?
Confiscated.
live law, my lord, second paragraph.
Once it is confiscated.
What is the judgment is, the name is Madhya Pradesh versus Uday Singh,
My lord, Uday Singh, my lord.
Ah,
Uday Singh also I have given, my lord.
para 2.
My lord.
Para 2 you are reading.
My live law,
The appeal arises from the judgment of a single judge.
my lord.
Hmm.
And there, my lord, the in Uday Singh, my lord, paragraph 29, my lord. Another judgment, 29, 20 in the
Hey,
court.
complete this. Let me
My lord.
understand what this judgment says. Which paragraph you are relying upon?
My lord, paragraph, my lord. My lord. Try giving one copy.
Madhya Pradesh.
कुछ ही है जो.
Page 3, my lord.
Yes.
3 last paragraph.
Yes.
As a whole, perusal of the decision rendered by the Supreme Court
Uday Singh.
in Uday Singh Supra does not find support of the submission of the London Council for the that the intention of the Supreme Court was not evident that direction for release of a seized confiscated vehicle in spite of bar available under section 52C can be issued by the High Court while exercising the jurisdiction under section 226 to 7 of the Constitution of India, but the Supreme Court has deprecated that the order of the High Court hereby confiscated vehicle was directed to be released in the petition under section 42 CRPC, object for not using any direction that is self available in the observation made in paragraph 29 of the decision, I deem it is produced paragraph 29 of the reproduced paragraph 29 of the proposed of convenience as under 29. Our analysis of the amendment brought by MP Act 20 Forest Act 27 leads to the conclusion that is specific provision have been made for the seizure and confiscation of the forest product and for tools, boats, vehicle, and article used in the commission of the offense. 21. Upon a seizure under section 52(1), the officer affecting the seizure has to either produce the property before the authorized officer or to make a report to the seizure under subsection 2 of section 52. Upon being satisfied that a forest offense has been committed, the authorized.
You read 52C first.
My lord.
52C.
Central Act, my lord. To Central Act. Which my lord? Central Act.
Shall I read 52C?
My lord.
It says, on receipt of the intimation
My lord.
under subsection 4 of section 52, about initiation of proceeding for the confiscation of the property, magistrate have a jurisdiction has a bar.
Right.
The magistrate, when exercising jurisdiction under 457, need to be intimated that confiscation proceeding has already been initiated. Then the bar operates.
That has not been, my lord.
Then in your case, what happened?
My lord, the
In your
magistrate.
case, that time when the magistrate passed the order, that time it was not there. That's the
Magistrate
only
order.
difficulty. The bar doesn't operate.
My lord, subsequently that has been, my lord, they done, my lord, while the revision court,
We are testing the legality of the order of the magistrate.
my lord. And also so also the revision, my lord, the,
Revisional order is something different.
my lord.
Revisional order, revision court is limited jurisdiction. Revisional court has to see whether magistrate order is correct or not. He has said no illegality. Anyway, take it out. The petitioner, the vehicle numbers are different, so everything is taken. The which is
What is the confiscation proceeding, my lord, in fact, my lord,
DFO, yes.
page 3 of the revision court order, my lord. And order dated, my lord. 30th, 9/2022, my lord. But page number 3, internal page number 3,
Page 3 of this
revisional court's order, my lord.
annexure.
Further, since the confiscation proceeding,
Which annexure you are talking about? Yes, yes, come on. Page 49.
Yeah.
It starts from page 48. Come on, page 48 of the petition. Which paragraph you are reading?
revisional court, what is the
Page 50 को देखो तो sir,
paragraph 3, my lord.
Hmm.
Further, since confiscation proceeding has already been initiated by the CP number 6 of
Wait,
2021-22, my lord.
Where are you reading?
Your lordship will kindly see para 4, page 50. My learned friend is missing the words
No.
50.
because it is.
No. Why are you confused? 48 is the annexure 7 is the revisional order.
My lord.
Where are you reading?
48, my lord.
Page 50 देखो,
Revision order next phase.
No, sir, dita judgment है.
50 टा देखो.
Dita judgment है. My lord, page, my lord. Page, my lord, paragraph 4, my lord. Page 50,
50.
my lord.
Which revision are you referring to?
First, my lord.
First one.
My lord, the revision number
5
17 of 2022,
50.
my lord.
50. Okay, come on. 50.
Paragraph 4. Towards
50. Yes.
after, my lord,
Let it public prosecute.
my lord. And public on behalf of the petitioner for the release of the vehicle of the party number by the resident Bhavani Patna, contend that the vehicle in question was used by the accused OP himself in committing offense 21 of the Orissa timber and other forest product transit rule 1980, and he used his vehicle for illegal transportation of the forest product, and therefore the seized vehicle is liable to be confiscated. Further, since confiscation proceeding has already been initiated by CP number 8 of 2021, CP number 8 of 21-22 under section 56 of Forest Act before the authorized officer, the order passed by the lower court for release of the seized vehicle is completely arbitrary and illegal.
Lordship may kindly see the beginning of the para. That is the submission of the petitioner. That is not the.
I am saying,
that is
we
not
are
the-
saying that confiscation proceeding already been initiated, my lord.
He has not said whether on 8/4/22 a confiscation proceeding was there or not. Because on 8/4/22, the learned magistrate released the vehicle.
Confiscation proceeding, ready? This office member dated 14/3/2023, 22.
Master notice is issued. The moment receipt should master to the call for report.
Showcase by notice जाइता हूँ.
Showcase पे notice वाला. Showcase ना दे यार release करे पके दो. हाँ.
Showcase notice.
हाँ. Subsequently release है 2/23 my lord showcase notice.
Page 39.
Page 39.
Annexure 1. Annexure 8.
Subsequently annexure my lord 3. Subsequently my lord the master release vehicle my lord. There are another notice that I put out.
ଦୁଇଟା notice ସବୁ ମୁଁ ଲେଖିଦେଇଛି ଦେଖନ୍ତୁ.
ସେ ଆର ଗାଡି ସେ ଆମର କଣ ସମ୍ପତ୍ତି ଅଛି? ଆମେ ଏଥିରୁ ପଢୁଛୁ। ଏଇଟା ନାହିଁ notice ନା କଣ?
CP number.
The present petition is filed by the DFO inter alia challenging the order dated inter alia challenging
They have not challenged the order of the learned SDJ.
challenging the
They have challenged
order-
only the order of the learned session judge.
1 minute, I am writing, I've spent sufficient time. Inter alia challenging the order dated 12/10/2022 passed by the Sessions Judge Kalahandi in criminal revision number 17 of 2022, whereby the order dated 8/4/2022 and 13/4/2022 passed by the learned SCM Bhavani Patna in criminal case 14 of 2022. What you say? The revisional court has dismissed the revision petition. The present petition is arising out of an application moved by the opposite party under 457 CRPC for releasing of the vehicle. The SDGM, SDGM Bhavani Patna, by its order dated 8/4/2022, has been pleased to direct the release of the vehicle with the following conditions. Please, last conditions, only conditions. Following condition. The said order was assailed. Next order. The said order, the aforementioned order of SDGM was assailed by the petitioner before the revisional court. The revisional court, while dismissing the appeal inter alia, dismissing the revision inter alia, stated as under para 6, page 52, and page para 6 and 7. Para 6 and 7. Para 6, 7, 8 and 9. 6, 7, 6 to 9. 6 to 9. Mr. Have you filed Wakalatnama?
Yes,
Where is that Wakalatnama?
my name has come.
It is come. Has it come? Just check it up. Wakalatnama. No. Okay. I have Mr. Sahu, Mr. Sahu on advance,
Mr.
Professor Sahu on advance notice have appeared for the opposite parties.
Vasudev Pujari.
Vasudev Pujari appear for the party. And next, Mr. Rogada appearing for the petitioner. Inter alia contends that there is a specific bar under section 52C for release of the vehicle. Release of the vehicle under 457 KRPC when the vehicle is involved in a offense related to forest act related to forest act. The perusal of the provisions indicates that the bar would only operate.
Another matter, may I check? So, for Odisha is concerned, my lord, section 56 of supply 3, my lord, provision. But it says that
It has to be initiated. I'm writing judgment, just see. The bar would only operate once the confiscation proceeding is initiated and informed to the magistrate. However, in the instant case, when the application under 457 CRPC was pending before the court of SDJ, and admittedly at that point in time, no confiscation proceeding was initiated. So therefore, the bar under 52C of Forest Act indeed was not operating against the magistrate from dealing with the application under 457. When the matter stood that the SDJ accordingly allowed the application and imposed the various conditions as taken above. When the matter was taken up to the revisional court by the petitioner, the revisional court was testing the legality of the order of the magistrate and accordingly rejected the revision petition. The petitioners are agreed by the state. Taking into consideration the aforementioned position of law, Mr. Ragada also, Mr. Ragada relied upon the judgment of Madhya Pradesh High Court in WP number 18604 of 21, passed on 30th September 2021. He emphasized on para 3 of the said judgment, para 3, Mr. Ragada relying upon the provisions of law in the Indian Forest Act and the judgment cited has vehemently contended that the order of the revisional court is not sustainable under law. On contrary, Mr. Pujari has taken me to the order of the SDJM and the revisional court and contended that since there are SDGM, the court of SDGM, while allowing his application under 457 CRPC, has imposed various conditions. The petitioner has no prejudice, even if the confiscation proceeding has been initiated. Since the condition for release of the vehicle mandate the opposite party to produce the vehicle as and when required, and he has also indemnified. He has filed an indemnity bond to that effect. He would be participating in the confiscation proceeding. Participating would be confiscation proceeding and contest the proceeding on merit, on merit, on merit, merit, on merit. If on merit, since the condition of release of vehicle make it mandatory for him to produce the vehicle as and when required, depending upon the outcome of the confiscation proceedings, he would produce the vehicle before the authority in the event he will not get success in the confiscation proceeding. Therefore, the impugn order, there is no infirmity in the impugn order. Therefore, there is no infirmity in the impugn order. As we say, is neither bar under law nor prejudicial to the confiscation proceeding. Confiscation proceeding stated to have been initiated by the petitioner against the property. It is dismissed. Which affirmative observation, both the petitions are order.
Separate
order.
Or when the confiscation order required the vehicle, he will produce before the confiscation order.
That is the order. What is the prejudice to you? Next. Yes. You succeed then. You have to produce. You proceed with this confiscation proceeding. Who stops you? Yes.
Yes, but petitioner before let's say is the wife of a government servant.
Wife of a
Government servant. The husband has been implicated in a case under section 13(2), 13(1) of PC Act and read with 109 of IPC. Now I am in 109 of IPC.
What your husband was doing what?
But initially I was my husband was the constable, subsequently ASI of police. But the entire case is that admittedly some property stands in my name. There is no dispute about it. But my submission is merely because some property stands in my name, I cannot automatically implicated in a case under section 109.
You have to tell the source, that's all.
My lord.
You have to tell the source.
Yes, but I have disclosed my sources.
What are their sources?
But I disclosed in my affidavit that some Siddhan, that means gold ornaments I acquired, and that I sell it and purchase some property. But this is not a big amount. Question of this is not a big amount.
How much?
The total DA is 117%. Less than 100%, my lord knows. So far as Group C, Group D is concerned, there will be no criminal proceeding.
117.
117. 117.
What is the extent of property shown in her name?
In my name, Lord, stands some property. I think, Lord, near about, I have calculated 5 lakhs somewhat.
What was the source? You
2 lakhs, 5 lakhs somewhat. Here, my lord, they have come up a case that, my lord, kindly see the vigilance given reply. What are the allegations against me? How 109? You will also kindly see the affidavit filed by the Vigilance Department dated 30/10/2023.
30/10/2023. Additional affidavit.
Yes, sir.
Yes.
Sarat Chandra Sahu has sworn an affidavit. Investigating officer.
Yes.
Well, kindly see page 8.
8.
Page 8.
Here. Yes.
Sixth line from top.
The
petitioner had been examined. Well, kindly got it?
Has been examined.
Yes.
And
Petitioner had been examined and in her statement recorded under section 161 CRPC, she has stated that she was a housewife. Her husband had purchased 5 number plot Rikkapalli Mauja, one at Ramachandrapur Mauja, so and so. Her husband had made the deposit in her bank account and she made the household expenditure by withdrawing money from the account.
Departmental circular cannot supersede the statutory provision. Similarly, the contention is raised in the Yes, what do you want to say here?
Now, my lords, they have come up a case. So there is no abatement from my side. Well, kindly bear with me. My husband, but I'm giving an example. My son is a prosecutor in a class 3 student. He wanted a motorcycle. But father provided a motorcycle. Can the son included in your under section 109?
No, that's 109, but the other provisions are also invoked against you.
So that's why, my lord, my case, specific case is, since, my lord, I have not committed any kind of abatement or any conspiracy for acquisition of these disproportionate assets, I cannot be automatically included
Under
on
the
the
aid of
109.
109 only you have been prosecuted. What do you
Yes.
say?
Yes.
Only 109?
109.
Beyond 109, nothing is there.
Nothing is there against her.
How do you substantiate 109?
So far as if I made a fair submission, my lord,
Hmm.
in view of that statement, she is not liable under section 109. And she, moreover, she is not claiming that he is not filing any income tax return showing any independent sources of income or not claiming any assets which are shown that she has acquired those assets in her name out of that income. In absence of that, the lordship may consider.
No, I didn't follow. She doesn't file a.
So far as 109 will be attracted there, if a lady or a wife having no sources of income stated that I have sources of income and I am filing income tax return out of my own sources of income, I acquired that property, thereby intentional income. And she is not setting like that. In view of that statement also. Husband
Page 8.
Page 8. In view of that statement, that is the 161 statement.
What does it say? Let us understand. The petitioner has been examined in her statement 161. She has stated that
she was a housewife
and her husband has purchased 5 plots.
Man.
And she is not claiming that it is
she is a housewife. She was a housewife. So she doesn't have any, she admitted that she doesn't have any sources of income. And that husband has acquired in her name. So because of that fiduciary relationship, that can be. Taking into consideration the fact and circumstance and peculiarity of this case.
Reality is this, the husband is into mischief.
He has to pay.
Get the money.
He has to pay.
In the name of the wife.
Wife and children, that is right. Unless the wife claimed.
The only thing is the wife, the moment the property is acquired in the name of wife, wife has to go to the police and say that my husband has got some money.
That cannot.
Otherwise, everybody will come into 109.
That's why I'm saying that because of that fiduciary relationship, that cannot be. But unless and until she claims.
She may put up a defense.
To
say that
I have sources of income, I am filing false income tax returns and showing different sources of income, having no sources of income. Then and there, it should make it a fair way.
Doctrine of balancing. Then what else is there? What is the departmental circular you are talking about?
So far circular is concerned, it will not be applicable to the present petitioner's case. Say 100% to come hele. Principal the class 3 employee
principal I mean wife.
Here the wife is letting the proceeding may continue against
the proceeding has to continue because 117
Yes.
And if in any case, if your lordship will please to allow, then one line observation that taking into consideration the fact and circumstance and peculiarity of this case, it will not act as a precedent.
So what is the asset gold ornament of 7 lakhs?
No, segura sabu that cannot be adjudicated now. In view of this statement, your lordship.
Look, the petitioner had challenged the proceeding initiated against her under section 109 IPC. Next one. The petitioner is keeping watching up for the proceeding initiated against her by the Vigilance Department. under the aid of section 109
Of the IPC.
IPC. Good, sir. The husband of the petitioner is facing the prosecution in a disproportionate asset case arising out of FIR number so and so, arising out of FIR number so under so and so. The petitioner
But
is the wife of the main accused in the said FIR. The only allegation against the petitioner is there are certain assets in her name, Therefore, under the aid of section 109, she has been made as an accused and made to suffer the proceeding. The petitioner in the present proceeding is assailing the entire proceeding and entire proceeding initiated against her. Initiated against her. Mr. Pradhan, appearing for the petitioner, submits that even if the allegations is taken at its face value, allegations are taken at its face value, no case as such is made out against his client under section 109 CRPC. The IPC. 109 IPC reads as an 109. The only ingredient which is required to attract 109 is actively. What is that? 109
intentional aid.
Read that provision 109. Where is the abutment?
109.
107.
108. Huh?
Oh,
107. It is an active participation in the abatement of the crime. The abatement is described under section 107, which reads as in the light of the above provision of law, if the statement of the if the allegations are weighed, no case as such is made out against the petitioner. The statement of the petitioner, under section 161 CRPC. Where is that? Where you say that?
Page 8.
Page 8, para 8.
Para 8.
Para till 10.
Making it clear that although she owns the assets, but she has not claiming that she has an independent income, and trying to justify the
acquisition of
the assets. Acquisition of assets. In the absence of any defense put forth by her by justifying the assets acquired by her, and on the fact that she is plain and simple stating in her statement that the properties are purchased by her husband in her name per se will not attract the definition of abatement as contemplated under section 107 IPC. When it comes for the opposite party, no, I will not write this thing. The counter, benefit would be could be derived from the counter filed by the opposite party in this present case. The para, which para?
Para 10, page.
Para 10 reads as an para 10. Page 6 counter para 10. Page 6 of the reply objections. Page 6 of reply objection. ठीक है ये एफिडेविट दी जस्ट उल्टा सीधा उतार दिया शरद चंद्र साहू एफिडेविट
My lord, आयु
शरद चंद्र
आयु your lordship may record आयु
हाँ सर व्हाटएवर नहीं रिप्रोडक्शन रे ಯಾವ ಕೂಡ ಉಡೇತು शरद चंद्र एफिडेविट रे पारा 10
पेज 7 ने अछि पारा 10 आज
पारा 10 उतार पारा 10 नहीं पारा 10 नहीं
पारा 10 paragraph 10
पेज नहीं
Page 8, page 8.
it starts from page
from
6
page 7.
हाँ पूरा वो पूरा पारा 10 टा उतार
हाँ.
पूरा पारा
नहीं better
reading from the
may I suggest one
taking into consideration the stand taken by the opposite party.
may I suggest one thing my lord?
Para.
Para 7 no, page 7 in your lordship in reply your lordship in reply
पूरा पारा उतार देंगे ना पक्का खत्म
my lord
पारा 10
ସେଥିରେ ଅନ୍ୟ ଗୁଡ଼ା ଅଛି in reply
तू यूज करो ठीक है
हाँ
you para 10 रो in reply to the aforesaid contention सब para 10 रो सब para humbly submitted the deponent you do ठीक है first portion go right second portion it starts like in reply to the aforesaid contentions to the criminal proceeding ठीक है taking into consideration the stand taken by the opposite party in the counter affidavit and material available on record. I am of the considered view that the role attributed to the petitioner does not attract the provisions of 107 IPC. Therefore, the petition deserves merit. The disproportionate asset, since the petitioner is not putting forth her defense inter alia stating that she has independently acquired the asset alleged to have been in her name. It is the onus is on the main accused to prove the source of the income on the basis of which the assets were acquired in the name of his husband, name of his wife, name of
he is also
his wife.
you also
So no, in the foregoing circumstances, the petition is allowed, and the and what is this? And the criminal prosecution arising out of FIR number so and so, and consequential proceeding.
Why against the petition?
Therefrom, vis-a-vis the present petitioner is quashed.
Why against the petitioner is quashed?
Why against the
petitioner
petitioner
is
is
quashed. May one line your loss. Taking into consideration the fact and circumstance peculiarity of this case, it will not act as a precedent. It will not act as a precedent.
Needless to say that the present petition is based on the facts of the present, peculiar facts of the present case, peculiar present case.
It will not act as a precedent. This order will not act as a precedent for others.
The court of record, if anybody is taking advantage of this order, let
it is clearly different. That's why I'm making.
Obviously, every case facts are different.
Then your lordship may observe so that it will.
I'll observe. Yeah. Next.
May please, your lordship.
Yes.
My lord, this matter was before your lordship yesterday.
Yes. Yes.
My lord, this concerns about OPID Act, Section 6. What I was submitting before your lordship, that the matters are all before the Honorable Apex Court, my lord. I have given a bunch of orders of the Honorable Supreme Court.
He's given the paper. See, I keep it here, you need to throw it. That's the old paper. He has given yesterday. You have given this.
Yesterday, my lord, I had handed over.
Have you given the bunch of the orders and all?
Yes,
Yes,
one
my
order.
lord.
Where is that? ये कौन सा मैटर का था Leave it on record. I suppose. In a loose paper, it should be there. Where are you searching? Do you have any other copy?
No, my lord, we have no other copy.
My lord, actually, yesterday only 2 copies. Earlier date we have already
Okay,
given.
it's all right. I got it. Yes, tell me. Yes.
Yes, my lord.
Your lordship kindly come to page 21 of that
Yes.
bunch of orders,
tell
my
me.
lord.
Okay. Yes. However, insofar as the prosecution under section 6 of OPID Act is concerned, the offences thereunder is not made out, as OPID Act cannot be allowed to govern the field of the real estate so-and-so, simpliciter so-and-so. Okay.
Yes, ma'am.
Next. Then,
Then your lordship kindly see, the state went up in SLP to the Honorable Apex Court and the judgment has been stayed.
yes.
That is next page, my lord.
Yes, I got it. Next.
My lord,
thereafter
that is number 2107 of 2022.
Hmm.
This was passed on 13/4/2022. Then, my lord, in the meantime, that petitioner before that case, my lord, filed a petition to change the court, my lord. Transfer the case, my lord, because one section 6 is not maintainable, then it will go back to the learned STJ Bhubaneswar.
Right.
That was dismissed by this honorable court at page.
I got it. This is
Yes,
House
my lord.
judgment. I got it.
Yes,
Next, what
Page
happened?
29. Page 29, my lord.
I know,
Then,
I
my
got
lord,
it.
page 30, this was stayed by the Honorable Supreme Court.
Supreme Court, right?
And tag it with SLP criminal 2107 of 22. Then, my lord, there is another case, my lord.
Similar case.
Similar case. Damayanti Naik, next page, my lord. Damayanti Naik and another
that is also now tagged with the main matter.
Yes, my lord. That
Yes,
is also
ma'am.
stayed, my lord.
that operation, my lord.
What is this
32.
Nivedita? What is this Nivedita?
My lord, they have also filed this challenge this section 6 OPID Act, my lord.
Nivedita is also pending.
Yes, my lord.
Pending. And then, my lord, Nivedita
Jagajeevan.
Das. Yes, my lord. Then, my lord, at page 36, my lord, Nivedita Das, again, the state, Nivedita Das went to the Honorable Apex Court that other sections may
Yes, I
be
got
not
it.
processed. Yes, my
All
lord.
these matters are pending. You tell me what you
And then, my lord, another case.
I got it, sir. Sir,
Yes,
I got
ma'am.
it. Yes. Yes.
My lord, sole contention is basing upon the judgment rendered in CRLMC
Yes.
2136.
This is
They are
raised judgment,
Miller.
which is pending in Supreme Court in many other matters also.
In many other matter, and Nivedita Das case judgment was pronounced analogous hearing with that Rasmita Patra on the same date judgment was pronounced.
Hmm.
That the judgment rendered in Rasmita Patra case will follow in Nivedita case. That was the order,
Hmm.
Miller. And the same question was raised, Miller. And this honorable court held that the judgment.
That must be also pending in Supreme Court.
No, this is not.
How can this court say that a judgment
Because
is
the
pending in
earlier-
Supreme Court in per incuriam?
Miller, because the earlier decisions has not been taken up in the subsequent
But
decision.
that will be decided in Supreme Court, not by
Yes,
the bench saying. Wait, which paragraph?
Miller. Page para 8.
8, huh?
8. Fifth line from bottom.
Hmm.
On a reading of judgment CRL number 32 of 20, it is made to understand that charge under section 6 of the OPID Act was under challenge therein, and same did not find favor with this court, which was also followed in CRLMC number 2781 of 19. Therefore, the only option is now left Open to conclude that the prosecution against the petitioner for the said offence shall have to continue. However, its facts being dependent on the final decision of the appeals court so and so.
No, no.
That is just stated that.
No, just say, CRLMC number 1296. Where is that? 1296.
1296, Miller, they have referred, Miller. 1296, that per right before that. The subsequent judgment in CRMC 1296 of 2021 without taking note of said decision has lost its binding effect. The per right is detailed. I am placing from beginning of per right.
Yes.
Yes, Miller. Referring to the appeals court decision in Ripa Sharma and other decisions cited herein, among laying down the principle of binding precedent, and that if conflicting view is taken by a coordinate bench of the same court in ignorance of earlier decision, it shall have no binding effect and said to have a judgment of per inquiry. Mr. Bhuyan, Law and Counsel for OPD States submit that the earlier view of benches of equal strength was to be followed by subsequent bench of co-equal strength while dealing with similar matter. It is claimed that since the coordinate benches of this court confirmed the order of charge and initiation of criminal proceeding, the subsequent judgment in CRLMC 1296
Yes.
of
Without
2000,
taking note of the said
yes,
decision.
a lost its binding. But
Ripa Sharma is not taken.
however, it's argued by Mr. Das on a senior counsel that judgment in CRLMC number 2781 of 19 is a non-speaking one, earlier judgment, which simply followed the judgment CRL 32 of 2020, which was related to an order under section 239 CRPC seeking discharge. It is contended by Mr. Das that RERA governs the field, which is a complete code of in itself, and therefore the doctrine of occupied field squarely applies. On a reading
Doctrine of occupied field squarely applies.
On a reading of judgment in CRL 32 of 20, it is made to understand that charge under section 6 of OPAD Act was under challenge therein, and same did not find favor with this code, which was also followed in CRLMC number 2781 of 19. Therefore, the only option which is now left.
You have to tell me where is the 32 and factually what is the case here and what is the case 32.
I will place.
Yes.
Open to
conclude that the prosecution against
the said offence shall have to continue. However, its face being dependent on the final decision of appeals court.
Again, the same thing. However, it depends upon the fact.
But proceeding will continue, but the final decision will
The same thing it says that
and next line is important. And as a necessary corollary.
Corollary, it is declared
Yes.
it is parent curiam. That's
Yes.
right.
Yes.
But if they having taken note of the fact that it is parent curiam, the court says that it is subject to outcome of the Supreme Court judgment.
Well,
Obviously, whether it is parent curiam or not, the Supreme Court will decide.
Yes, my lord.
So therefore, if Supreme Court decide, what is the fun in troubling the court below and wasting time?
Yes, my lord.
Right.
Another thing, my lord. Your lordship will find from the certificate of the cause title, one CRLMC was mentioned. But fact remains that 3 CRLMC was filed before this Hon'Ble court by the petitioner and the company.
What to do? This is the whole difficulty in our court.
And
Nobody
Miller,
discloses.
interestingly, an order was passed in the same case. CRLMC.
Right, the other which is not disclosed.
No, not this.
Amakes.
Yes, yes.
You have,
In
not
CRLMC
disclosed and-
2497.
this is Jagajivan. This is also Jagajivan.
Yes, petition number 2. And company represented through MD Jagajivan. Miller.
Yes. What is it?
2497. Para 7.
Yes.
As it appears in this case, the petitioner had filed CRLMC 1126-19 during the investigation of this case, which is still pending. The petitioner, without disclosing the same much after filing of charge sheet and cognizance taken in this, presents by order dated 9/7/18. The present case, 9/7/18 was called. Has filed this petition with the aforesaid period, that too has made period to quash the entire criminal prosecution in city case number 3 of 18. And also I have filed a competent authority to make the attachment absolute under section 9 of the Vedic in the decision.
Attachments are the
So also
related.
the complaint made before RERA authority. Section 13 of the Opioid Act states that any person including the competent authority is agreed by an order of the Legislative Court may prefer an appeal before the High Court.
Whatever, this proceeding is not disclosed.
No,
Why have you not disclosed this proceeding?
My lord, this matter was in criminal miscase number 3167 of 2022, my lord. That was withdrawn on 15 to
There is,
2000.
no, another criminal MC case number 2497 of 2019 was filed by Jagat Jeevan Naik, petitioner number 2, which was dismissed, and you have not disclosed.
No, I have no instruction, my lord. But the only thing is, my lord, further proceeding.
The clients are getting wiser by engaging in different counsel and without disclosing, they want to procure order from the court. Why should the court be lenient to these kind of people, those who have tried
My lord, can I intervene, my lord? My lord, can we take instruction because this now they are giving this order, my lord. I have to seek instruction on that.
My lord, the only thing is, your lordship would be inclined to.
I'm really persuaded to say the proceeding. There is no difficulty, but do you think that
My lord, let that order stand, my lord.
litigant of this dubious character deserves any sympathy?
My lord, let that order stand.
He will render the lawyers appearing for them in trouble, the prosecutor in trouble, and the court is also.
May I be pardoned to say that let that order stands, but further proceeding on section 6 will be stay.
No, it is dismissed, sir. This is dismissed. This petition, they have dismissed it.
That is against attachment, my lord.
no, proceeding was.
He was claiming for quashing the entire criminal prosecution.
My lord, here only it is OPID 6.
It is only for OPID 6.
He was asking for entire prosecution to be quashed, including OPID 6.
Yes.
Which was dismissed.
My lord, in view of the changed circumstances, can I pray before
I'm not on that. Why your client has not disclosed the things to you and not in this petition? If you start encouraging the people of this character, then it's a very dangerous proposition. See, this same gentleman, petition number 2.
My lord, that I am very sorry.
You need not express sorry, sir. It is because of your client this is happening. They might not have told you.
Yes, my lord.
Might not have told you. You clarify and file an affidavit. If at all I'll give state, I'll have to I'll put it on Friday. File an affidavit regarding this. I will, if at all I will stay the proceeding, I'll impose very, very heavy cost on him. And then only I'll entertain this petition.
For builders, cost is no matter, they will pay the cost and.
No, let them pay at least to the bar at least. The difficulties they have not disclosed.
Allegation about
No, but
10
the
crores.
difficulties they have not disclosed to the lawyer. Lawyer of his stature is appearing and saying he doesn't know means see what is happening. So these people are very dubious people, you know. They'll render everybody in trouble. Right.
Next week, Friday, I have next week.
Yes. The counsel for the opposite party at the outset wanted also that the petitioner number 2 early approached this court by filing CRLNC number 2497 of 2019. The original by the automated CRLNC 2497 of 2019 seeking quashing of the entire proceeding initiated against it. By the order dated 2/3/2021, the Parliament has dismissed the proceedings. Dismissed the proceedings. Now, this fact is not disclosed in the present petition. Then the senior counsel Mr. Patnaik appealing for the petitioner submits that the client has not disclosed regarding the filing of the earlier proceeding. Therefore, he seeks time to clarify this condition and file a separate affidavit. The matter is adjourned to 19.
My lord,
My lord, 19 is, will be little difficulty, 20th.
20.
20.
Yes, my lord.
You file an affidavit, we'll see.
Yes, my lord.
Yes, my
Yes,
lord.
Everything has to come on record. Then-
Yes, my
Yes,
lord.
yes,
Yes,
my
my
lord.
lord.
Because it appears he is not
Because
instructed
they,
to go through.
my lord, they do not know the intricacies of the court,
Right.
my lord.
Maybe whatever may be the reason,
Hmm.
or they
They
may be
could have
knowing more than.
disclosed, my lord.
Hmm.
No,
Yes,
they they must be knowing more than all of us. That's the problem.
Yes, my lord.
Yes, my
Let
lord.
us see. Let us see.
Yes, my
Okay.
lord.
Please, Your Honor. I am saying second case, I am for the opposite party, my lord.
Mhm.
In first case, my client last week supplied me the counter. This filed this case, my lord.
The client will file the counter.
Let me
As a petition. For that reason, registered the case.
let me go through the
What do you want now?
to his time maybe allowed
No,
to go through the
Time not required, my lord. Since the connected matter, my lord. This is serum recovered. Zero two. There is no matter the no post matter. It has been annexed attached with the serum C 1 2 1 2 2 9 and go to 1 and go to the assignment.
Okay, that 21.
20.
Tag the matter with what is that? The
1,229 of 21, Your Honor.
Since this is subitem, is the petition filed by the
Opposite two matter.
opposite party number 2.
It's 2021.
And this court doesn't have to assignment deal with the same matter. Let both the matter be taken before. So then with the assignment. But if you are on the
Your Lordship, interim orders to extend.
I will not say anything because today I am recusing
Then,
to
Your Lordship,
whatever it is.
the interim order, Your Lordship.
That's not pass order. Once I say that it will become court, I will not say anything. 21 matter will not say.
Your Lordship, in my matter, there is an interim order.
It will be continuing to say that.
Lordship,
I'm not.
Lordship, Lordship.
Yes. We are going to go to the. How many? Leftover matters are remaining complete. Okay. I guess.
direction for reinvestigation of the matter. I think petition is the informant, lodge a FIR, it is registered as Telkoi PS number 54, dated 18/5/2021.
Why the investigation?
What is, my lord? The charge sheet was a file under section, my lord. 341, 323, 535 IPC instead of 307. Petition intention, it is to file under 307, my lord.
How it is maintainable?
No matter, my lord. They have to file there before the magistrate reinvestigation. And final charge sheet already been submitted, my lord.
Then
My lord.
And if, my lord, if
482 courts
and
are
then
not
after, my lord, during course of investigation, if the material comes, my lord, the charge can be altered.
Naturally.
That is available with them, my lord. And they can also file another complaint case, my lord. 307, and that case will tag with this case, my lord.
Withdraw the petition to avail the remedy under law. Under law before the court will with the petition is disposed of with the aforementioned liver. Yes. With the liberty as correct. Yes.
Help some allegations, help some content in both the affairs.
Lordship,
Lordship, last occasion, Lordship, I remember.
2 FIR registered, and in the FIR, exact similar word has been used.
Wordings have been used
Your Lordship has
and
observed that.
different police station.
And last
In this
occasion,
way,
that is
the
the
police persons are entered with the petitioners.
Hey, notice was issued to.
Yes, my lord, yes, my lord.
Lordship has called for the case record and then instructions by the state.
Directly, my learned senior to take instruction in that matter.
Yes.
But I've got instruction, my lord. Case diary also available with me, my lord. But what happened in this case, my lord? These petitioners, both the petitions, both the cases, my lord, they are having criminal antecedents, my lord. They are, my lord,
In this way,
my lord, they are habituated with the doing this type of offense, my lord, all the offense 379 against, my lord, petition number Ashok Kumar Mahapatra. There are 10 cases, my lord, similar allegations, my lord. They have, I can say, but they are the smuggler, my lord, so far are concerned, my lord. And so far the petition another case, my lord, Fakhruddin Khan, there are 5 cases pending against them, my lord. These case diary show that, my lord, they are deliberately doing this type of, my lord,
No, the last order was,
my lord,
it was said, para 8,
my lord.
Let counsel for the petitioner submits that they would be extending cooperation to the investigating agency so that the investigation in both the affairs could be concluded to ascertain as to whether
They are not cooperating. They are anticipating action rejected.
That is there, but they should issue notice.
That has not been disclosed, my lord.
Unless they issue notice, how can you cooperate? They should issue notice unless.
They wanted the no course of action.
The last order was that you have to extend.
Yes, we cooperate unless they issue notice.
Call them.
Yes, you issue notice to us.
If they will, my lord, they will go to the IO, my lord. But they wanted no course of action. They are, even if they are not.
I am not going past.
That is it. We are ready to cooperate. You should issue notice to us so that we can go.
On 7/1/2024, notice was issued to the opposite party, and in opposite party, full stop. In the following direction was made. Invited ones. Mr. Raghuda, appearing for the state, submits that the investigation is still on. However, the same could not be concluded as the petitioners have not extended cooperation. On the counsel for the petitioner submits that they were never called by the police to cooperate. The matter is adjourned to, they go coming, adjourned to so awaiting the outcome of the.
Let them issue notice, my lord. Let them call so that will.
You give.
Yes, your lordship, observe that. Otherwise,
But the moment
I will direct everything in a portion.
the moment the
How will you do, how will you work?
that is correct.
definitely the I
They will, unless they will notice the.
Do I have a jurisdiction to
No,
direct?
sir, certainly not.
No,
No.
I am consciously writing
Yes,
this
yes.
thing.
Let,
I can't say give notice, call him, give a copy to him.
Man, police time and again, man, they have asked that man.
You are right.
Then proceed.
You are conducting raid for arrest.
Ask for issuance of warrant, whatever.
Man,
you want.
You are conducting raid for arrest. How can we cooperate? Unless you called us.
41 notice. Why don't you give 41 notice? They'll come.
Yes.
But habitual offenders, man.
Habitual, yes.
10 cases.
But let it be 1,000 cases, but you have to investigate and file a charge sheet or file a closure report. You can follow the
The
procedure.
moment that I was sent the case that to the son report in BLPLM or my lord, in that case, the moment that I rejected, they fled away from the area, my lord.
How can you, my lord? You noticed us so that we can go and cooperate.
Procedure is there.
Yes.
What to do, you know. We
It is urgent or disposal.
No, it's simply urgent. You tell me either one of these FIR is wrong.
Yes.
I just want to know which is wrong. I'll watch.
That is, your lordship.
My submission before both the affairs are correct, my lord. As because
Let it be investigated. It is at the investigation stage. Let us understand. If both are correct, then both the petition will be dismissed.
Yes, ma'am.
You investigate and tell. That's and arrest them if you want. And give 41 if you want.
Unless
ask for NBW. Many procedures are there. You do it. You people, the difficulty you people made it as a profession.
For that,
That's the difficulty police is after you. Invest.
May I please, your lordship?
Yes.
My lord, last occasion, your lordship was pleased to direct my lord and senior for the state to obtain injury report regarding the matter.
Settle.
My lord, matter
Yes,
has
what is
been
the
settled.
injury report?
my injury report so far is concerned, my lord. They have gone to the some hospital, my lord.
What report submitted by the some
Okay,
hospital?
let him continue.
There are my lord, injury reports also there, my lord, but not grievous.
Not grievous. That's right. So we'll cause it. Where is the accused?
Sorry, my lord.
Where is the accused?
Accused myself for the accused, my lord.
I'm sure that you are not the accused.
Sorry,
Where
my
is the
lord.
accused?
Sorry, my lord, I have not instructed for to present with.
They can't have the luxury of
Oh, your lordship
home
keep
at,
it. 16th, my lord, they will appear.
16th.
16th, my lord, they will.
Call them so that.
My lord. Though both the cases arise from same issue. Sorry, extremely sorry. Some matter. Both some matter.
16.
No, 8. 2 items.
16th, I am given the date.
My lord. Both the matters of obliged, my lord.
My lord, may kindly look at page 12. 138 case, your lordship, the company is not a party. Prosecution is only against the director.
Who is there?
No, it a phrase.
Where is the complaint? Only director.
Only director.
Let us see whether it is a company or it is.
I am a company.
Where the complaint? What does it say?
Page 6, Srinivas Sahu, such and such, MD Land and Water Projects.
Let us see in the personal capacity you have given what?
हाँ sir, page 6 रे. Column 2.
I'm talking about the content of the complaint. क्या complaint file करते हैं? This complaint will not.
Accused Srinivas Sahu has given a check of Axis Bank, Rasulgarh, Bhubaneswar, such and such, to the complainant, and the complainant deposited the said check at Corporation Bank.
You have given. Where is the company has not given?
Company has given.
Well, how do you? The complaint doesn't say company is given.
Pay in Annexure 3.
Huh?
Annexure 3.
Annexure 3.
My lord.
Yes.
That is the check issued by your lordship in Land and Water Projects Private Limited.
The petitioner is being accused in a complaint in ICC case number 11 of 2014 initiated by opposite party number 2, no, opposite party under section 138 NIA. The petitioner is Mr. Suddenly that account for the petitioner submits that although the check was issued by one what is that? Yeah, limited. What is it limited? What is it limited?
Land and Water Projects Private Limited.
Land and limited. Huh?
Land and Water Projects.
But the complainant, opposite party has filed the 1CC case against the director of the state company, namely the present petitioner. Therefore, the complaint is not maintaining. He has relied upon the complaint at Annexure Annexure 1 and also the photocopy of the LA's photocopy of the subject check Annexure 3. Annexure 3. Issue notice to opposite party, retainable within 2-3 weeks. In the meantime, the proceeding before the which court? Proceeding before
my lord.
JMFC
LR Bhubaneswar. No, LR my lord. JMFC LR Bhubaneswar.
JMFC LR Bhubaneswar in ICC case number 11 of 2024, 2014. State for the total. Okay. Give the date. Yes.
May I please your lordship? My lord, this
Yes.
is your matter already settled. Informant already appeared and filed affidavit before the oath commissioner of the Hon'Ble court. Matter already been settled within the part.
Where is the accused?
Your lordship may keep it is 16. I have 16, my lord.
Where is the accused?
But in fact,
Accused and informant. You don't never know.
in fact, offense 395, my lord.
That is knowingly, my lord. They known to technical 395, my lord.
All are there.
Technical 395, my lord. Both informant and the accused person known to each other.
That is why he committed the crime. No,
Otherwise,
each other, therefore,
sometimes happening, my lord.
bring them.
My brother carrying much knowledge than me.
But we bring them. You never know.
Obliged.
Sometimes these accused may allege against you also.
Your lordship
Don't
give
take
it
that risk of doing it. 16.
16th, my lord.
All them.
Obliged.
Yes. Paso. Paso. 13. 1-3. 1-3 pass over. 12 passed over. Okay, come. You had already entered the courtroom. There.
I'm so sorry. Apologies.
Okay. Well,
So this is one of its kind of case where the petitioner has approached this honorable court under section 482 of CRPC on the plea that the surety which has been provided by the accused to go on bail is her property and has been fraudulently deposited as surety for the accused. It is a case of OPID.
Just give the copy to the OPID council, my lord.
Let me complete. In fact, what has happened? The opposite party, who happens to be the opposite party number 2, is an accused in a default of financial irregularities,
okay.
and he has taken deposits from many people for development.
He is facing OPID.
Yes.
He got the bail.
Yes.
And he forged the document to
No,
give
he has
surety
not
of your client.
forged the document, but he provided that as a surety to go on bail, and that land belonged to me because I had given that land for
You are not
development.
signing the bail bond.
No,
So you have initiated a proceeding against him.
The proceeding has been initiated by public. Those who are depositors, because he was a developer, he took money to develop that land and sell flats. That land belongs to me. I was in partnership with this accused person. A 30-70 ratio partnership. I had given that land to develop with a notarized agreement only. That should not have been accepted.
You are a co-accused along with
No,
the
I'm not a
number two.
co-accused. I'm not a co-accused. The sole accused is the OP number 2. I am the landowner
I
who
understand why this proceeding then.
this proceeding was initiated on behest of the depositors who have given to the accused number 2. The
For releasing of the property, he has filed this.
Releasing a property.
Yes.
Up to date concerns a
Yes,
required,
yes.
my lord.
Releasing a property, then have you
Open
applied to the trial court?
I have applied to the trial court,
Huh.
but there is no power to release the property under section 443. 443 reads as thus, that envisages that he should be committed to the custody again if any fraudulent security is seen, but that does not provide for refund or release of the security.
You have initiated any proceeding against the opposite party number 2,
I have filed an application for release of that property only.
but you have not initiated any criminal prosecution.
No, criminal proceeding I have not initiated.
Yes. What the trial court says?
The trial court says that that is the property which has been seized as the subject matter and has been under attachment. The subject matter of the dispute about the in the OPID Act. So that cannot be released till the civil miscase, the proper proceedings are over.
Correctly saying.
But the only problem is
But
this,
you are the. You are
I am the
wrong-
owner.
That's right, but you are in the wrong company. What to do?
By virtue of a notarized agreement, that also should not
Whatever,
have been.
you are in wrong company. Your partner, who knows he is a partner? What kind of partner he is?
But I should have been made an
If
accused
this
charge sheet.
property was subjected to, a fraud, then how can it be released like this?
My lord, I'll just explain. I am not an accused in that case. Charge sheet submitted
You may
since
not
law.
be, but you are land. You are the partner.
Yes.
You should be happy that
I
you
am
are
a
not an accused.
victim. I am a victim as well.
Under the aid of 109 or something, you could have been 120B. You could have been an
So
accused.
that could not have
Be
been.
happy that you are not an accused. You are a effective.
I am a victim rather. I am a
You are a
victim.
witness against your own partner.
I am a witness as well as a victim.
But you are.
Because my land could not be developed. That is under the position of this.
What are the proceedings you have initiated except asking for relief?
No, I could never have any other independent.
You have entered into an agreement with him.
Yes.
Rightly or wrongly.
My lord, a notarized one.
Whatever.
My lord.
Have you sought for cancellation of that? You
No.
have not done.
No.
And you are partner. You have chosen a wrong partner. He made you a victim.
In fact, it was
And
not
the
a
partner is
partnership.
for that land only.
It was not a partnership. It was not a business establishment. It was not a partnership. But it was
Development agreement.
yes, development agreement. I was not a partner. I didn't have any share in his profits. It was that he will give me apartment and he will also sell to others.
It's difficult for you to get out of this.
Because 443, how it, my lord, envisages.
Well, I will simply issue notice. Issue notice.
My lord, he has to only serve copy.
Sir, the copy to the opposite side. Let us see. Simply issue notice. But you have a bad case because of the bad company.
I am on a sticky wicket. I understand that. Still, it is a vacuum.
Maybe whatever you are saying is correct. Maybe innocently you might have thought that my property will develop. But
Yeah,
what to do?
is that is the also case of the OPID court. OPID court recognizes me as a victim as well. But he says I am undone because that is subject matter of attachment and that can be only done after civil miscases are
But when
disposed
you
of.
enter into a development agreement with someone, you have to see the character of that man also. That is a due diligence. What else?
Yes, that is also
If you are
correct.
purchasing something, due diligence is qua the land. If you are entering into a development agreement, due diligence is knowing the person.
He didn't have any past records. It was only subsequently developed.
Anyway, issue notice, returnable within. Serve the copies.
Yes, ma'am. Any shorter date if I
We'll just see. Yes. Yes. That pass over. Yes.
14.
Very good. Withdraw. Please give me 15.
15.
Please, na? Adjust.
16.
More nine. More 17.
17.
My lord may be taken up after lunch.
Good. After
Lunch, my lord.
pass over.
Much only.
My lord, may I please in item number 18?
Yes.
My lord, I pay for some time, that is after
Adjust. Yes.
next week, my lord, because the conducting
19.
counsel is absent.
You simply ask for adjournment, I have accepted it. Don't decide the date.
Obliged.
Okay.
19.
19. 47, sorry. 20.
19. Item 19.
19.
Yes.
Okay. Yes.
My lord, item 19. Petitioner challenge the order of cognizance, which is under annexure 3.
Yes.
My lord, it is running test 26 and 27.
What are the allegations?
Allegation, my lord, my lord may come to running test 25. Brief fact of the case.
You tell me.
Yeah, the case is that, my lord, the petitioner is the relation of the complainant. Complainant is the, my lord, real estate. He was doing real estate business. He alleged that he has since I was the employee of him, I, on my personal capacity, I and my relation, another accused, we both executed sale deed. He said that I should, since he is my employee, by committed a breach of trust, he has executed sale deed without my knowledge. So that is, and saying that is from my own money.
All these facts are there.
My lord,
That is-
my lord, before going to the merit of
That
the
is
case, here is a case where the anticipatory bail has been filed and another 482 application which
What
has been
about
dismissed.
other 482?
That is not trace, that was for non-prosecution. That was
Not trace. It is dismissed for non-prosecution. So he is to file an application for restoration.
Dismissed for
Without filing restoration, again 482.
1 minute. The petitioner had earlier approached this court
CRLMC number
for the same relief by filing CRLMC number
656 of
656 of 2019.
656 of 2019.
19.
The said petition was dismissed for non-prosecution.
My lord.
And the petitioner has filed the present petition express in agitating the same point.
Yes.
Same issue. Agitating the same issue. Learned counsel for the petitioner seeks to withdraw this petition to revive his earlier petition. The present petition is expressed as withdrawn. We could liberty with the petitioner to revive the earlier petition number 2. Revive.
Item 20. May I please, your lordship?
Only here,
Yes.
petitioner is the informant, my lord.
Yes.
And the offense under section, my lord.
What do you want?
My lord, what, my lord? My lord, during investigation, my lord, what the investigation progress, my lord, your lordship may kindly say answer 3, my lord. That is page 18, your lordship may kindly say.
Yes.
I have submitted a report that offense under section 3 SCST Act is not made out. During the pending of the investigation, my lord. Investigation is not completed yet. So such
cognizance is taken now.
No, my lord. Your lordship may kindly see page 18, your lordship may kindly see. Answer.
Yes.
Pursuant to the order dated 3/9/2023, the IO is present in the court today and files updated case diary. Along with prayer, wherein it has been intimated to this court that since no evidence of commission of atrocity to the informant is made out, therefore the offence punishable under section 294/506 read with 3 of ST Act, my lord, is not made against the.
In view of this term, there is no offence.
My lord. Here allegation, my lord. that the informant was defrauded, and when he asked about the defraud, he abused him in obscene language, saying in the name of his caste, my lord, caste and some others.
The remedies are,
My lord,
remedies are there with you, not 482.
My
You
lord,
file a separate
no,
complaint.
why, my lord, I have filed this case, my lord, because whether court can do this or on the prayer of the IO, that this is not made out. When the
But
prosecutor,
482 court, how can it examine? You have other remedy, you can file a separate complaint. You have to, other remedies are in CRPC. I can't examine the material to say that this case is made out or that case is not made out.
Only the
record has been remanded to the residuum from the special court. It's a
From
case
this
of
court to
3
that
years.
case.
He can very well file a separate complaint.
Complaint file kar protest petition.
Protest also. You have a remedy under protest. You can file a protest petition. You can
Yes,
file a
at the time of filing of charge sheet.
complaint. So many things. But 482 court
So
can't
this
do
could
that.
have been done, my lord, if the filing of charge sheet would have been done and said that this is
They'll
not
file
allowed,
the charge sheet
that would have been
thereafter.
otherwise.
Wait, let them file the charge sheet, then you file a protest petition.
Yes.
That's the remedy.
But now at this stage, my
I'll
lord,
give you that liberty. I'll give you that liberty. But
your lordship,
then the petitioner is assailing the order dated 11/9/2023, whereby on the basis of the report made by the IO of the case, the charges, the allegation, allegation under section 3(1), yeah, 3(1) wala, HA, has been dropped. Huh?
as well as 294 or 526.
And then drop, full stop, drop. The matter is at the investigation.
Yes,
phase.
yes.
Awaiting the report under section 173.
Yes.
CRP. The petitioners have other remedy to pursue under the criminal procedure code, at the appropriate stage, appropriate thing. Therefore, the present petition is premature. Hence, the counsel for the petitioner seeks to withdraw this present petition to avail the remedy under law at the appropriate stage. With this observation, the petition is dismissed. Yes.
I may pardon, madam. Item 9 रे टिके 16 केस टा भूल ही I may be permitted to correct.
Which item you are talking about?
Item 9, madam.
When you have to talk? Then I made a clear. If don't jump into inside the proceeding and tell something. We are following a system. If you have any mentioning while rising or when sitting, that time only it's permission. Okay. Okay. 31. Yes.
May please, your lordship.
Yes.
Challenge, my lord.
Otherwise, this will be Machli Bazaar.
Yes, yes.
Anybody will come and
anybody anytime.
Anytime anybody will come and do it.
Lord,
This exception can be given to only seniors.
Seniors.
Senior counsel, that too senior means senior.
Two seniors.
Age by senior,
Age
not
by-
designated senior.
deeply.
Young designated senior also can be.
Yes.
Deeply. Oh, this.
Yes.
My lord, here, my lord, the impugn orders number 13/12/2023, where by the designated court, my lord, reject, my lord, known, my lord, default bail, my lord, 167.
167.
My lord, here is a case, my lord, that without filing the FSL report.
What is the procedure we follow generally? He will file the.
Yes, sir.
You file in the trial court. You file the bail and take
Lord,
the ground.
My lord, that was rejected. That is the impugn order, my lord. It was rejected.
No, bail application, regular bail application.
Yes, my lord, that was also, my lord,
You
rejected.
moved on 167(2).
My lord, this is, my lord, 167(2). My lord,
Supreme Court has not answered the matter.
That is pending before the Honorable Supreme Court.
Supreme Court.
The final decision has not yet been called.
That not answered, I know.
Say yes, no.
They are, my lord, they have granted interim bail to the petitioner. That is, my lord, the division of the bench of Honorable Supreme Court has granted it bail, and it was referred to a larger bench, and larger bench, my lord, allowed the and confirmed the judgment of the division bench.
Supreme Court
The interim bail. Division bench of Supreme Court also. And there also, my lord, in the larger bench also.
Where this continuation of the interim order? What is it?
Larger bench pending is final decision has not yet come up.
Larger bench is pending, but the bench has given interim order.
Yes, my lord. That is, my lord. And
That
the
is
division bench
I
of
think
Honorable
that
Supreme Court.
order before my lord that pendency.
My lord,
Before the
here,
Supreme Court.
here, my lord, division bench, my lord.
This is after.
Yes.
That's the problem.
You'll also make an one copy.
Give the copies, let him verify, and I'll take
Yes,
it
yes,
up.
you'll also
I'll take
make
it.
Just, I will.
ଆପଣ ସବୁ ଦିଅନ୍ତୁ ମହାରାଜ ବାବୁଙ୍କୁ
Copy
I'll take it up. This is not only in your case. It will
Lord.
help him assisting in other
Your
cases.
lordship will pass an order for all time to come.
Mr. Panda arguing another case, my lord, similar type case, 167.
So please examine.
Yes,
Let us
sir.
see.
And I also get the instruction of whether the chemical agency report has been filed or not.
Yes. That too after
Issue notice.
And some decision copy.
Mr. Maharaja accept notice.
Yes.
And Mr. Swami has relied upon certain judgments to press for interim relief in the present matter. Mr. Maharaja seeks time to examine the issue involved in this present matter. Urgent to 29, 28, 29. 29.
29.
29. And take a completely comprehensive view and assess so that we can decide which matter it will help others also.
Others also.
Instead of doing piecemeal matter.
Any copy maybe?
Very short question in
The entire thing you.
फाइल करिए ना मत दे देबे
दे दे
ना फाइल कर देले से
No, you must give him.
Personally.
Personally.
I know. Personally, I will give.
Yes.
22, last occasion, Lordship wanted to peruse the statement of
It's to 29.
29.
20. There is what? I have not said anything. Of course.
last occasion, Lordship wanted to peruse statement of
What is the case?
Case is, my lord, my application under section 311 is rejected. And on that event of rejection, I before this application. Some specific was
PW1.
yes, my lord, the only witness. PW1 is the complainant and
Why
is the
you not
witness.
cross-examine for the
Yes, my lord, cross-examination part is there.
इंडिपेंडेंट पार्टी क्वेश्चन प्लस कॉपी देना थे हमको 311 पिटिशन
311.
311
Once is complaint case.
What is the offense?
Offense 138, NI Act.
138.
Madam.
The notice you
नोटिस जो
notice you have.
विदाउट नोटिस रे हमें किसी ऑर्डर भी कर पाए
Ex parte order we can't pass, no? In a complaint case.
इट्स अ केस ऑफ 138 इन एक्ट
Notice gale kongi that matter is about to argument, about to posted for argument. So there is also possibility to pronounce on judgment after argument. So if the notice will go, I have only two questions. The entire case rests upon story is that the complainant lent a hand loan to the accused, and in that in order to pay back that amount, he issued a check which could not be encashed and returned with degenerate, and case is filed. I have only two questions, that the place, date and time of the hand loan and the source of the hand loan, because the complainant is a housewife. So what is the source of her income? This is the only two questions. I have no more questions at all.
Whether that has been
But you have issued the check.
Yes, my lord, I have issued the check.
Why have you-
Not to her. This check is kept for security purpose. In fact, my lord, the
By the way, why have you not cross-examined her?
সেই
I've
কপিটা আছে কি
submitted
ডিপোজিশন কপিটা?
হ্যাঁ দিয়েছি।
Mark read to my counsel.
Even
ফার্স্ট ডিপোজিশন কপিটা।
enter touch that.
Advertently. Now you have not cross-examined. What to do? You take say there is problem.
স্পেশাল মেসেঞ্জারে
Why
নোটিস
have you not cross-examined?
My lord, another counsel has conducted the case. And
Now
fresh,
you have cross-examined at very length.
a very length cross examination, the specific question only,
তাহলে
only specific question.
Just see. This is a part of the evidence. Where is the other evidence? Where is para 1, 2, 3? Nothing is there.
That is the only chief. This
No,
is the
no.
part of the cross examination.
No, you start from para 12, para 12 and 13. This is the examination chief itself. Thereafter, cross-examination you have done once on
In two occasions.
6/5/2023, and thereafter again you cross-examine on 8/11/2023. There are two cross-examinations. Now you need third cross-examination, and so elaborate cross-examination.
Yes, my lord, elaborate cross examination is there, but only questions raised to be put that only.
Maybe you question, why have you not put the questions?
Fact is that
So many questions you asked, relevant question you didn't put according to you, and now you want that the complaint. I will only issue notice. I will not stay because of this lengthy cross examination. If no opportunity was given, I can understand. I
Yes,
can
yes.
say and immediately I can put it. Full opportunity was given.
my lord,
Twice he came
my lord.
to the box, and you have at length you have cross examined. Now you want to recall, then you may have a right question which you have
Exactly,
left
Lord.
not. I'll just issue notice.
Only
Issue.
two questions, my lord.
I'll
What
issue
basic
notice.
questions
Whatever.
like?
Why have you not asked these two questions if it was so relevant? You asked 1,000 questions, leaving that two important questions. according to you.
Fact.
You have to justify.
My lord.
Then why have you not just see recall is only possible if sufficient opportunity is not given to you. Recall is not possible if keep on getting wiser by changing a counsel, better counsel. The counsel may say that, oh, these are the two questions you should have put, and you change another counsel, he may think that another
No,
five
ma'am.
questions are relevant.
Case has come to its final conclusion.
Whatever.
Matter is posted for argument and judgment may be pronounced. That's a fact.
That's right. You have see when was that cross examination? This cross examination has taken place on May and November, and you are coming now. What to do? Right now, issue notice. I'll give a short date. Issue notice, returnable within 1 week. Put it on 20th. 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 Yes. You file requisites and do immediately.
Right.
So that I can give one opportunity and finish.
Yes.
Okay.
Okay, madam. All right.
Yes.
God bless me.
Lordship, in item 23, this is the Belgium material, Lordship. Issuance of NBW.
How many? 2 matters are there.
Yes, your Lordship.
Why 2 matters?
Lordship, both are from similar PS case.
Same,
your Lord.
2 different accused.
2 different
You
accused.
first talk about the first matter.
Yes, your Lordship.
The first matter is accused are
Akuna alias Ankuna Babina.
when he got bail.
Lordship got bail on dated 16/4/2021.
16/4/2021. NBW
issued on 12/12/2022.
500. Huh? Next one. Next.
On next your
Next
Lordship,
matter is
Milan Mishra.
Milan.
Milan Mishra.
Milan Mishra. When you got bail.
Lordship released on bail on dated 8/7/2020. And then NBW issued on dated 12/12/2020.
500. Next.
Yes.
May I please, Lordship, my lord, this is the Belgium Metro, my lord. NBW order dated 22/11/2023, running page 10, my lord.
Bail, when you got the bail.
My lord, present petition already released on bail, offense under section for 57,380 of IPC. The present
Tell
petition.
me the date.
My lord,
Date when you got the bail.
charge sheet forwarding is condition.
There's some bail.
My lord,
And could not appear 2022/11/2023, 500. Or give all of them the today you give the date. Court. ठीक है 500.
Yes, sir.
25.
मतलब Belgium matter, my lord. And as well, the presentation is bail on 16/9 of 2016, my lord.
16/9/2016, yes.
And NBW is, my lord, 4/11 of 2022.
500. Yes. Next.
My lord, this is a Belgium matter, my lord.
Yes.
My lord, NBW issued on 6/11/2003 and bail granted on 18/11/2009.
19.
Yes,
18/11/2019.
my lord.
And
By the honorable court.
NBW 6/11/2023, 500. Yes.
Obliged, my lord.
27.
Wait,
Yes.
Belgium matter. NBW issued on 11/9/2023, your lordships. They have been bail on 12/5/2016.
12/5/2016. NBW
11/9/2023.
500. 8.
May I please, your lordship.
500 each, huh? There are two.
Yes, lordship.
500 each.
May I please, your lordship. 3 petitioners are there. Lordship, NBW issued on the same day.
20. Okay. Oh, bail.
Lordship, bail, first petition number 1 was released on 17/9/2012. Second petitioner was released on 24/1/2014. Third petitioner was released on 13/11/2012. And NBW issued on 7/4/2022, Lordship.
500 each.
Grateful, my lord.
Total released on bail, my lord, 2/2/2016. And NBW, my lord, 13/2/2023.
500. Yes. 30.
Item 30, Lordship, pray for Friday. For Friday, because the petitioner and opposite parties, the matter has been amicably settled between them and they will be appearing.
They will be appearing. Okay.
Yes, sir.
What is the offense?
Offense is 195 5.
Okay, you bring them. 16 or 19, whatever. 16.
16.
31. Pass over. 52.
Belgium matter, my lord.
Yeah.
Petitioner granted bail on 17/4/2020 and NBW issued on 25/7/2022, my lord.
500.
Please, your lords.
33.
33, your lordship, I am praying for a shorter adjournment. Kindly be taken up next week, convenient to any day.
You ask for only adjournment. Huh? Rest, leave it to the court.
My lord.
Urgent.
My lord, in fact, Josh, now I have it.
Whatever. Your prayer is accepted. Yes.
Interim order is there, your lordship.
The interim order there, that is the reason.
No, I am not praying for a longer date, any short date next
No,
week.
why have you not, have you filed the process, requisition and all?
No, my lord, that has already been complied.
Let's take it up. Otherwise, I'll vacate the interim order. That is the reason I'm not giving interim order. Once interim order is given, then you keep on adjourning the
No,
matter.
my lord, my learned senior is the only opposite party, your lordship.
While taking adjourn, interim order, senior will come. Thereafter, you keep on, don't file requisite, don't come to the court and enjoy the interim order. I'll vacate the interim order.
My lord, Josh, now I have been
If you have
solved.
not filed the requisite,
33.
vacate.
33.
In couple of matters, I'll vacate, then court proceeding will be taken.
My lord, I am extremely sorry, your lordship. Only next week, any day convenient with
Huh?
that.
You have not filed for requisites. What is this? You have taken stay and you don't file requisites and don't come to the court.
There is defect, one defect is there, 14 IV, defect is there.
This is what, how the proceedings are. Huh?
My lord,
This is not accepted.
my lord, requisites, direction was there only to serve one extra copy to my learned senior, which has already been complied with.
Opposite party number 2 है क्या इसमें?
That's my kindly have my plans to order dated 16/2/23.
Yes, there is no opposite party.
Only state is the opposite party. I was to
No,
support.
there are two.
No.
Exactly.
There is no.
IO and IH and also.
What happened to, what is your instruction in this?
Pardon?
What is your instruction?
Instruction, my lord, in fact, my lord, charge sheet submitted in this case, my lord. And they, my lord, filed this present petitioner for remission or for that reason they have filed this case, my lord. And
I don't think you have clear instruction.
My lord,
At least the matters where there is a stay operating, you should be ready. So that we will vacate the stay. If they are asking for adjournment, we will proceed. And if you are also not ready, let them take.
So far, my lord,
Take
they
advantage of this. Simply adjourn it. What to do? You are also not ready. You should have, at least where there is a stay order, you should be ready so that I will hear it. I will not adjourn it.
and on their, my lord, the application and also the annexures, I am ready, my lord. This case, my lord. But this case,
Give a short date. Give a short date. But make it a point where there is a stay order.
my lord.
Be ready, even if they are asking for adjournment, I will not.
In fact, in the present case, my lord, they have no case, my lord, at all, my lord. The charge sheet submitted on 363 and 363, my lord. On the basic on the 161 statement of the victim, as also 164 statement of the victim, my lord. Now they came forward and filed in this case, the investigation is not performed, the investigation was performed, and the case may be reinvestigated. That is their case, my lord.
My lord,
How can, my lord, this one would direct the for reinvestigation, my lord?
But there is say okay, give a short date.
my lord,
Huh?
no, it is a case under EC Act, your lordship.
First mark I am giving. I am making it clear that
33.
the on behalf of the counsel for the petitioner, he has come. If there is a stay operating, I was reluctant to give adjournment.
Let them answer, my lord, the point which I have raised.
Instead of 397 to 23, my lord, the file given to me 24, my lord. For that, I agree, my lord.
My lord, because I had argued this case long back.
I'll tell you why we took little time. Wherever there is a stay, I am
ready to argue this case. I am ready to argue this case. My lord.
But he is not, when you to your benefit is not ready.
But it's a very short point.
I know it's now urgent, he is not.
A wrong file given to me for that reason. 23, my lord, 390, CLM is 390 23, but file given to me and
Whatever.
324. my lord.
Now we need to his benefit.
Answer that way.
My lord, if you may verify a judgment which I had argued long back.
Take the file and whatever you want.
93 volume 6 OCR 726.
Yes, next.
93 volume 6 OCR.
Take it so that the next time at least wherever there is a stay, be ready for hearing. That is the reason I don't give stay.
After lunch,
No, today it's not possible.
Kebe asibo? Last match.
Intermodal to continue.
Well.
Intermodal to continue. Yes.
34 may I please, my lords.
Yes.
My lord, this is an application for quashing of the criminal proceedings. My lord,
Yes.
offenses.
What is the offenses? I could see that.
My lord, allegation is with regard to that the present petitioner, while during his incumbency as the secretary of Sri Nilagiri Chara Ganesh has misappropriated a fund to the tune of rupees 13,40,250. And my lord, he had not submitted the statement of expenses, my lord. And to that effect, my lord, I have filed a declaration suit which is at Annexure 2, my lord. And He has been appearing, my lord.
What is declaration?
My lord, that is at annexure 2, my lord.
That's right. Who are you?
My lord, I was the ex-secretary of
Rajesh Kumar Mohanty.
yes, my lord.
Okay.
Yes, ma'am.
Against you have filed against these people. Who are
These
they?
people, my lord. The present general secretary and other members of Sri Nilagiri Chara Ganesh Guruja, my lord. The trust.
What is the case against you?
My lord, the case against
What is the allegation in the
my lord,
FIR?
allegation in the
FIR filed by whom?
my lord, it was arising out of a 1cc case which was instituted at their instance, my lord, against me, and the allegation was I had misappropriated
It is
certain amounts.
156 It is 156(3).
Yes, my lord.
Huh?
Yes, my lord. Arising out of a 1cc case, my lord.
In this case, Lordship, I'm appearing for the informant, Lordship. I'm appearing for the informant. The conduct of the petitioner, he has around 4 cases to his name. He has antecedents. I'm passing on the antecedents.
I'm not deciding bail. Antecedent maybe what? What is
Bail
the
and
merit of it?
As far as the merit of the case is concerned, he has misappropriated 13 lakh something odd, and by using the PAN card of the Chara Ganesh committee, Lordship, and when we are filing TDS, the tax that has been deducted through the source is now returning. So the amount around comes around 20 to 22 lakhs. I have all the documents, Lordship. I pray to file an affidavit to that effect, that by using the name of this the Chara Ganesh temple name, Lordship, he has misappropriated lakhs and lakhs of rupees.
What was he in that?
He was the
Secretary.
secretary since 2015 till 2018. And when audit report was asked, when he was asked to submit the audit report, he refused.
What about the suit he has filed against?
Lordship?
He has filed a suit against.
Civil suit, yes. As he has been debarred from that, he has been removed from the committee. He was asked for show cause. He did not file a show cause. Straight away.
Different story altogether.
Lordship.
Misappropriation on the ground of misappropriation, you have been removed. You file a suit.
Yes,
That's a different cause.
Yes.
But fact that you are whether you are misappropriated or not, that will be
Subject matter.
tested in the trial.
Yes, my lord.
How can it be caused like
I
this?
know, my lord, but investigation is at a premature stage, my lord.
So then comes for the petitioner. He has filed the present petition seeking quashing of FIR number so and so, arising out of 1cc case number so and so annexure 1, and the investigation is that is at its threshold. Therefore, threshold. Let counsel for the petitioner and threshold, therefore, this court is not inclined to interfere in this matter at this stage. The learned counsel for the petitioner seeks to withdraw this petition to raise all the point, all the issues at the appropriate stage, we should report below with the liberty the petition is.
My lord, liberty if further cause of
Liberty have you?
obliged.
Yes. Yes.
Your Lordship, last time your Lordship ordered to implead the complainant, but due to cardiac problem, my senior was hospitalized. So may your Lordship kindly give 2 weeks time.
36. Yes.
Your mother, the notice was issued to the opposite party, number 2, and it has been treated to be sufficient, but he has chosen not to appear, I think. That is the noting, I.
Ready return after valid service.
On OP number 2.
No, this is not correctly furnished.
What is this case then?
Yes, pilot, petitioner He's a practicing lawyer of Sorobar, my lord. He has overreached in the sense he had accompanied with his client to the house of the complainant. They are some sort of tug of words. And it is also stated by the complainant in her first information report that the advocate who had accompanied with this said he has taken name of my caste, Sari, Chindali, Chuttajati, Paluni. And that was said by the other accused. Mumo okila nahi gaschi.
ছেড়ে দে নচেত নালিকুঠা ছেড়ে দে নচেত নালিকুঠা
Cheli,
দেখিয়ে দিবি
with regards to
ছেড়ে দে নচেত নালিকুঠা দেখিয়ে দিবি
Simply on the last on 30th January 2024, notice was issued to the opposite party number 2. As per the SR report, the notice is although sufficiently served, duly served to the opposite party, but there is no one appeared on behalf of her, Timothy, on behalf of her, on behalf of her. Then Mr. Dal, learned counsel for the petitioner, submits that the allegation against the petitioner inter alia is, what is the allegation? You just tell.
That he had accompanied with the other accused, named in the affair.
That the petitioner being a lawyer, accompanied with the other accused.
Main accused.
Accompanied with the main accused.
His name is Tapan Khatal.
Main accused Tapan Khatal to the house of the informant, and the accused persons have threatened the informant. So on the basis of which the present FIR has been lodged. The counsel for the petitioner is seeking indulgence of the court for quashing the FIR.
Charge.
Quashing the charge.
My rejection of the order.
Charge. What are charge? In fact, charge already.
No.
The petitioner is indulgence of the court for setting aside the order dated
by
13/2/2023, whereby in the
special
court
judge,
of special judge Baleshwar has rejected the application of the petitioner under section 227 CRPC. CRPC. Next paragraph, the matter is urgent to afford one more opportunity to the opposite party number 2. Opposite party number 2. Next. In the meantime, the proceeding in the special case number 375 of 2016, pending before the special judge bracket SCST Baleshwar, is stayed till further out. Date is March 5th. 37. That's first. 38.
31 500 বলেছে 38
39.
পেপার adjournment আছে পেপার adjournment
Urgent.
yes
Yes. 40.
40 pray for 1 week time. That's
Urgent.
yes.
41.
Your Lordship, on behalf of Mr. Manas Chand, please kindly taken off 1 week after.
You have interim order? No, urgent.
No.
Hashtag.
Okay.
Urgent. 42. Yes. 43.
43 possible, Lordship.
44.
May I please, my lord? My lord, kindly have a glance to annexure 8, my lord. Annexure 8, relevant page is running page 69, my lord. The petitioner filed an 147 CRPC proceeding for removal of the illegal wall from his plot, my lord. Relevant page is running page 69, my lord.
69.
69, my lord, is a part of annexure 8, which starts from running page 67.
Okay.
The impugned order is 18/7/2023, my lord.
Yes,
I'm
69.
page 69.
Okay.
I'm reading it out, my lord.
Hmm.
The case is put up today for hearing of petition dated 22/2023 and the petition dated 23/4/2021 of first party. The learned counsel for the first party has appeared and filed Hajira. The learned counsel for the second party has filed Hajira enclosing the citations. During course of hearing of the petition dated 22/2023 filed by the first party, the second party members have filed objection thereto, perused the same. The petition to recall PW1, the petitioner, is completely silent regarding the questions to be put to the witness PW1 by way of recall. Rather, some documents as mentioned in the petition are be proved from the side of the first party. My lord, these are the documents where the observation of the magistrate is that there is breach of peace, my lord. Now, my lord, I am again reading. Those documents have got no relevance in the present proceeding because the same are related to other proceedings under section 107 CRPC and 144 CRPC. Here my humble submission is the suit land is same. Proceedings are different, but the suit lands are same. Now, my lord, however, it is to be clarified that the present proceeding has been initiated under the 147 CRPC relating to removal of unauthorized constructions over the case land, and to that effect, first party has also proved several documents like Exhibit 1 to 7. Therefore, in my considered view, the present documents having no nexus with the present proceeding are not relevant nor throw light for proper adjudication of the present proceeding. Hence, the petition dated 22/2023 filed by the first party deserves no merit for consideration, and accordingly, the same is hereby
You are
repeated.
the first party.
My lord, the petitioner, my lord. The petitioner had filed this 147 proceeding. Here my humble Sanjeev Patri, my lord. My lord, here my humble submission is, if my lord pleases to go through the synopsis, my lord.
You want to say that the documents are relevant.
That documents are why relevant? Because
Therefore,
now
you want to recall that.
yes, my lord. Then very interesting part is I left, my lord, from the said order I am reading, my lord, 69. So far, the petition dated 23/4/2021 for the first party praying not to accept the inquiry report dated 7/4/2021, and for fresh inquiry report has got no legal force at all when there is no convincing reason to ignore the inquiry report dated 7/4/2021. Perused the said petition along with its reply filed by second party. So also gone through the inquiry report dated 4/7/2021 submitted by the IAC Balianta PS. The same being clear and cogent and free from ambiguity, the same cannot be ignoring the eye of law. Here my humble submission is why I am challenging the report dated 7/4/2021. I want to take your lordships to.
Now you are challenging to this order 18/7/2023 or the.
Yes, in that order, both the petition has.
There is no ambiguity in the report. You say there is ambiguity.
Yes, why? Because this report, I am referring to your lords, taking your lordships to annexure 3, my lord, 35. Running page 35, annexure 3. Because the IIC had conducted inquiry and there, after giving a report that there is no breach of peace, he asked me 5,000 rupees. I had gone to the vigilance. The vigilance red-handed arrested the ASI. That I have taken my running page 36, my lord. Running page 36, I may be permitted to read, my lord.
What is the stage of the proceeding?
Stage, my lord, kindly have a glance to.
Time listed, my lord. There are some opposite parties are there,
Private opposite parties are there.
But the proceeding pertains to 2021.
My lord,
That is, my lord.
Everybody might have forgotten now.
Because, my lord, on 18/7/2023.
Okay, we issue notice and stay the proceeding.
Private parties.
My lord, interim.
Interim.
Yeah, but
don't you want stay?
Yes, I want stay, my lord.
That's what I'm saying.
No, stay not there. First time came, my lord.
That's right. We issue notice to the opposition.
Said yes, proceeding is there, my lord. 15 ko post stage, my lord. That makes sense.
Issue notice to opposite party opposite party.
Opposite parties, my lord. Private opposite parties are.
Opposite party 2 to.
No, my lord.
It is 5 to 12, my lord.
5 to 12.
My lord.
Mr. Ragda, accept notice.
1 to 4.
1 to 4. 1 to 4.
1 to 4, my lord.
1 to 4. On behalf of 1 to 4. By way of the present petition, the petitioner is assailing the order dated 18/7/2023, whereby the 18/7/2020, what is the last? 18/7, which was 8, na?
18/7/23, page 69.
Whereby the regional DCP
Executive Magistrate Bhubaneswar
had rejected the application of the petitioner to recall PW1. PW1.
My lord.
The contention of the petitioner is that he wanted to place on record certain document through the by recalling, by re-examining PW1. However, the magistrate is of the considered view that the documents are not relevant. Then counsel for the petitioner submits that the proceedings under section 107 and 144 CRPC initiated against him pertaining to the same piece of land, pertaining to the disturbance caused in the same piece of land.
Same scheduled land.
So therefore, the documents relating to the land in subject are relevant documents.
Yes.
Relevant documents. Relevant documents. The land counsel for the petitioner further submits that the report submitted by the IO, a report dated 4/7/2021, submitted by the ISC Balyanta police station, which was relied upon by the executive magistrates, inter alia stating that there is no ambiguity in this order, is also liable to be questioned because the IO's report is motivated and the same are tainted also. Same are tainted also. Issue notice to the opposite party so and so. Okay. In the meantime, the proceeding, which proceeding is this?
Further proceeding running page 69, my lord. 67, my lord.
Further proceeding.
Criminal miss case number.
Proceeding in criminal miss case number
306
of 2021 under section 147 CRPC pending before the court of
additional DCP come executive
additional
magistrate.
DCP come executive magistrate Bhubaneswar state.
Deeply obliged.
Yes.
Item number 45 on behalf of Mr. Dayananda Mahapatra may be taken up next week.
46. Yes.
47, may I please, my lord? Petitioner is the bank employee more than 15 years. Allegation that Abdul Karim Khan was appointed in the institution as a customer relation.
What is the stage up for the investigation?
पैसा सब
Investigation to stage for
Investigation chalchi anticipatable rejected chi loss may kindly turn to
investigation
last
is
page.
going on and you are asking for passing. How can
A region order has been passed.
ଗୋଟେ ତାକୁ ଇଏ ଦେଇଦେଲେ ପ୍ରୋଟେକ୍ସନ ଟା ଦେଇଦେଲେ କି ରିଏଲ ପ୍ରୋଟେକ୍ସନ ଟା ଇଏ ହେଇଗଲେ ସେ ପଇସା ଦବାକୁ ଆମେ ରାଜି ଅଛୁ ଦେଇ ସାରିଲେଣି ଅଲରେଡି 1,33,000 ପ୍ଲସ ଆକାଉଣ୍ଟ ରୁ ନେଇ ଯାଇଛନ୍ତି ଆମର ଖାଲି 2-3 ଦିନ ଡେରି ହେଇଗଲା ବୋଲି ଏଇ ସବୁ ଧନ୍ଦା କରିଛନ୍ତି ଆମେ 2,41,000 ଆମେ 15 ବର୍ଷର ଏମ୍ପ୍ଲୟି ଆଉ କଣ ଏତେ ଅବିଶ୍ୱାସ କରିଛି ଆମେ ପଇସା ଦବାକୁ ଗଲା ବେଳକୁ ସେ କହିଲେ ଆଜ୍ଞା ଏଫଆଇଆର ହେଇଗଲାଣି ଆଉ ପଇସା ରିସିଭ କରିବୁନି ତେଣୁ ଇଏ କଲେ ଆମେ ପଇସା ଦବାକୁ ଆମେ ରେଜି ଅଛୁ ଯାହା ପଇସା
you should tell in the anticipatory bail court.
ବୋଲେ
Anticipatory bail you have got.
He also may kindly turn to last page. He has not marked the page.
এইটা
ABLPL 7161. That is annexed. Loss, you got it?
Yes.
7161 of 2023. Yes.
What does it?
Hardland counsel for the petition of the state. This is an application 437 petition apprehend arrest in involvement of offense 409 of IPC in connection
Alleged and revealed that from a fire that the present petitioner collected
lakhs of rupees from different persons
towards EMI
repayment of the join small finance bank, but did not make repayment of the same and they cheated the people as well as the said bank.
କେତେ ଲୋକଙ୍କଠୁ ପଇସା ନେଇଛନ୍ତି ଆପଣ?
ଆଜ୍ଞା
କେତେ ଲୋକଙ୍କଠୁ ପଇସା ନେଇଛନ୍ତି?
କେତେ ଏଇ ଯୋଉ ଅଳ୍ପ ଅଳ୍ପ ଆମାଉଣ୍ଟ ସେ ଡିପୋଜିଟ ଯୋଉ ଫୋନ ପେ ରେ ଦେଇଛନ୍ତି ସେ ଆମାଉଣ୍ଟ ଟୋଟାଲ ଆମାଉଣ୍ଟ ହଉଛି ତାଙ୍କର ଏଫଆଇଆର ରେ ଅଛି 2 ଲକ୍ଷ।
Forget about FIR, investigation is still on. Nobody knows how many
କେତେ ବାହାରିବ ତା ଠିକ ଠିକଣା ନାହିଁ।
ନାଇଁ ନାଇଁ ଆଉ କିଛି ବାହାରିବନି ସେତିକି ତ ଆମାଉଣ୍ଟ ସେ ଅଲରେଡି ଲେଖିଛନ୍ତି। ଅଲରେଡି ଏଫଆଇଆର ରେ ଆଇଡେଣ୍ଟିଫାଇ କରିକି ଲେଖିଛନ୍ତି ଏବଂ ଅଲରେଡି ପଇସା ଡିପୋଜିଟ ହେଇଗଲାଣି 2,08,000 ଆକାଉଣ୍ଟରୁ ବି ନେଇଯାଇଛନ୍ତି ଅଟୋମେଟିକ। ସେ ଆକାଉଣ୍ଟ ଇଏଟା ବି ମୁଁ ଇଏ କରିଛି।
But why the court has not given you bail?
Why it is rejected?
Why it is rejected?
ସାର୍ ସେ କୋର୍ଟ ରିଜେକ୍ଟ କଲେ କଣ କରିବା ଆଉ ଆପଣ କଣ କହିବି ସାର୍ ଆମ ଭାଗ୍ୟ ଖରାପ।
You have not implicated opposite parties also. Victims. To whom you want to pay the money to whom?
किसी तो
Mr.
कहा
Maharaj.
बैंक
Mr. Maharaj.
my lord.
You want to pay the money to Mr. Maharaj. You have not taken money from him.
You should have implied the opposite party. Nobody has.
Them, let us simply you have issue notice. Let us see. If you have if you are bona fide, then you why don't you go and tell the police that I am ready to pay? They may
Yes.
file.
You go and cooperate the investigation.
Cooperate with the investigation.
ପ୍ରୋଟେକ୍ସନ ଟା ଥାଉ ଆମେ ସବୁ ଇଏ କରି କମ୍ପ୍ଲାଏ କରିକି ସବୁ କରିବୁ ସେ
Protection ଟା ତ ସିଧୁ ପାଇଁ ନା
ବାଧିଦେବେ ସେଇ
I'll tell you, if you not have gone to the anticipatory bail court, I could have considered.
Yes.
Because if I pass an order, try to understand. If I pass an order, I am nullifying the order of a coordinate bench.
Yes,
I
exactly.
can't do in a 480. Try to appreciate that. I'm not a appellate court. How can I ignore a order of a coordinate bench? Wrong, right, whatever. If you are agreed to go to the superior court,
Yes.
go to Supreme Court, get it set aside. But once there is an order, I can't pass an order contrary to that order. Because that is coordinated. Had it been a DB Act, one would have
Yes.
thought of.
Yes, yes.
You may have a good case. But what to do? You have, you cooperate, just,
କୋପରେଟ କଲା ବେଳକୁ ସେ ତ ଶୁଣୁନାହାନ୍ତି ବାକି କିଏ କରିବ ସେଥି ଯୋଗୁ ଟିକେ ଟିକେ
nothing can be done. The petitioner is seeking quashing of the entire criminal prosecution initiated against him, wide CT case number 681 of 2023, arising out of Chandrasekhar PS number 269 for 2023, pending in the court of so and so. Mr. Maharaj appearing for the state submits that the investigation is still on. And in the meantime, unsuccessfully the petitioner has attempted to get the relief of pre-arrest bail from this court. And the ABAPL number 7161 of 2023 has moved by the petitioner has been rejected by the coordinate bench on 14/8/2020. Since the investigation is at its threshold, the petitioner, counsel for the petitioner submits that he would extend cooperation to the investigation agency so as to complete the investigation.
Yes.
He may do so. He may do so. He may do so. At this stage, this court is not inclined to entertain in this matter, being premature. But however, liberty is granted to the petitioner to approach the appropriate form of the appropriate stage, ventilating grievances, if any, disposed.
Okay.
So,
50. My lord, here, filing the affidavit, while filing the CRLMC, the FIR which is settled was not filed. I am for the informant. The informant filed an application complaint case alleging number of offences including 467 and 120B of IPC. And the reason is, your lordship may kindly
Now,
see,
whatever happened?
he did not, because if 467 will be registered, then 41A will not be applicable. So the IIC being gained over, leave it side for 67 and I-20, 120B. That is my grievance.
FIR.
Yes.
Investigation is on.
My lord?
Investigation is on.
And till now, my statement has not been recorded. Till now.
I can't guide it.
It's not
No,
a
no,
case.
not I'm that. But my submission is, the FIR may be accordingly registered because the court has directed. Your lordship may
This
kindly
is not
see,
maintainable.
156(3), court has directed to register the case.
Yes.
Where is 156(3)?
Yes, my lord.
Where is that?
And the
Complaint. Where is that complaint?
Yes, my lord.
I got 4.
Page 25, my lord. Order of the magistrate.
Yes.
Page 25, annexure 5.
Does it say that we, which section?
My top, my lord. A complaint petition under section 466, 5, 466, 467, 468.
What is the registered FIR?
The FIR is registered. I am giving the affidavit, my lord. Your lordship may kindly see. Page 3, annexure 6, my lord. Top.
465, 468, 466, 68, 71.
Yes, my lord.
What is left then?
467 and 120B. And for a moment, what is the forgery? Your lordship may kindly
In the
see.
investigation, they will bring all these things. What is the big
And
deal
this
about?
application itself is not maintainable.
My submission is, I am remediless because your lordship may kindly said that once the court has
You have a absolute remedy. If in the charge sheet they drop these charges, then you have a right to file protest petition. You have to write.
No matter,
the other right, sir.
if I do not object this, I cannot file a protest petition because case is registered under this section.
But in a 482 court, how can I alter the FIR?
No, I am not saying altering the affair. My grievance is that the order of the magistrate has not been carried out.
By the way, why police is doing all these things? 156 court says these are offense. Right, 1000 section. How does it make difference?
But for the sake of argument,
You write whatever.
Lordship is right saying.
Yes, my lord, in charge
Stress out what is made out.
Lordship is right saying.
Why
Number one.
you are forcing people to come to the court by not mentioning a particular section?
Exactly, my lord. Number one, it's an investigating officer who is investigating the case. He knows better.
You should
that
have
in which way
you should have educated them.
Yes, yes. That no dispute. And this
My lord,
application itself
put many sections.
This application
One page
itself is
only
not
section,
met.
all IPC sections.
But
How does it make difference? After investigation, you trace out
Yes,
what is made out.
That's true. But this application itself is not
my submission is,
maintainable.
my lord.
That's right. I understand it. My difficulty for, despite knowing the fact that your IO has played mischief, I can't help it.
And this is
Because he has the remedies. After investigation, he may edit or he may drop it. I don't know.
Yes.
I don't know.
Yes.
So let the
And if he
investigation
drops
complete.
it, then the remedies,
That is there.
other remedies are
That is there.
I can't direct in a 482 court to add sections in a FIR.
No matter not, I am praying for adding. Because court's direction is not complied with. That is my grievance.
You seek instructions.
No,
If you
but-
add it, or so.
Well, one thing, this application itself is not maintainable. Why should I take instruction? Lord? This is 482 application. Go for inaction of the police. Make the police as party so that the grievance will be settled. This is a 482 application, my lord.
I understand it. I also have a limitation. See, page 25, the JMFC while entertaining 156.3 has said the complaint.
See, effect ଅଛି ଆପଣ
Copy ଦେଲି ପରା।
ଏଟା କଣ ଗୋଟେ ପିଟିସନ
Copy ଦେଲି। But my instruction is
The
my lord.
wordings are, I'll tell you. Accordingly, the original complaint petition is sent to the IIC so-and-so PS for registration and investigation. So then, whatever the allegations are there, on that basis, you should have registered the, why are you unnecessarily creating problem? You're taking out few sections. 1 minute in complaint of what section you are saying.
And the forgery of valuable document is telltale matter.
See, page 19, just see. Page 19.
19.
The offense is committed. This is the complaint. The offense is committed is 465, 466, 467, 468, 471, 120B and 34. And the now come to the order of JMFC. He says that last order, accordingly, the original complaint petition is sent to the IIC Badambadi PS for registration and investigation. If the original complaint is sent to you to register the complaint, why are you dropping sections? For what good reason? Unnecessary, this is the smartness of the police, and which is not called for. If the JMFC says, register the case on the basis of complaint, you can't take view according to you. After investigation, you can drop.
Yes, yes.
But to begin with, you have to.
Yes.
Right. The petitioner is the informant in the present case. The informant had filed a 1cc case number. Informant filed 1cc case number 166 of 2023. 2023. Sir. The court of JMFC City Cuttack, after having been satisfied with the merits of the case, passed the following order with page 20. Page 20. The perusal of the order, the direction, precisely the direction of the court was to register a case on the basis of the original complaint filed by the informant. The original complaint indicates that the accused persons have allegedly committed offences under section 465, 466, 467, 468, 471, 120B, 30. The grievance of the petitioner, being the informant in the present case, is that despite a specific direction of the court below for registering the FIR on particular for allegedly committing alleged commission of offence by the accused person under particular provisions of law, the IIC Badambadi to drop the relevant provisions of law while registering the offence. The IIC Badambadi, pursuant to the order of the JMFC, has registered the FIR under two FIR, being Badambadi PS case number 269 of 2023 under section 465, 466, 468, 471, 34.
Yes.
34. 34. Kuda chhad deji.
467 and 120B.
Dropping
467 and 120B.
120B IPC. Therefore, the petitioner seeks indulgence of this court. Next, I'm conscious of the fact that under the inherent jurisdiction of the court, at this stage, the court ought not to have interfered in this matter. However, suffice it to say that the IIC should have complied the order dated 21/7/2023 to its letter and spirit. However, in the present case, the IIT has not done so. Learned counsel appearing for the state, Mr. Maharaja appearing for the state submits that he would seek instruction in this matter. Instruct in the matter and seek an adjournment. The matter is listed on 16 to come out.
16.
I'll call him. Yes. What is why he is
A free copy may be given.
Free copy.
Yes.
Item 9, Your Lordship, there is a mistake on my part. number that I 1cc number, your lordship, you should notice.
11 or something was there.
No, it will be 929. It was transferred from Jajpur to Bhubaneswar. So I will correct it.
You given na? He given a cheat. We have.
I will correct.
Whoever has taken the dictation is correct.
Both in the petitions, also in the, there are some defects. If your lordship allows me to correct it in the court.
Why don't you tell your juniors to be a bit serious in the High Court? In the petition mistake, in the prayer mistake.
When I was signing, there was no problem.
And the court is bound to do mistake in the order.
When I used to sign, my lord, there is would not used to be any problem. Now these people, they that's the problem. So your lordship may allow me to correct it. No, bhule hi wo. Kitne kotha koi.
Don't pass any order. Reject any order, list it.
With the lordship's permission.
It will be listed once again. I can't pass an order in a completely wrong petition.
Petition number ta bhulao.
Number is that is the whole game.
It will be 929.
You argue some case and take stay in some other case.
It will be 929.
To do.
The office man do it, my lord. 929.
Outside list kar do. There are many problems what to do.
With the lordship's
Again, it will be listed. Again, I may change my mind also.
Most welcome, your lordship.
With the lordship's permission. 1 second. I am for the OP. My friend is appearing for behalf of the petition. 139 in Act. 205 has been rejected. My submission before the lordship.
What do you want?
The petition may kindly allow. But the order dated 5/1.
Which item?
65.
Last time. I'll take it up.
My lord.
I'll take it up.
Sorry, I am suffering from truth. ଦାନ୍ତଟା କଷ୍ଟ ହଉଛି ସେଇଥିପାଇଁ ଠିକ ଅଛି ଠିକ ଅଛି ଦିଟାକୁ ଆସିବେ I will be there.
I remember it. You can go. You are conceding.
Concede.
No problem.
5/1/2024 ରେ ତାର ଆଲାଉ କରିଦିଅନ୍ତୁ ପ୍ରେୟାର କୁ ଗୋଟେ ଟାର୍ଗେଟ ହେଇଯାଉ ଏତିକି ଦିନ ଭିତରେ 6 ରୁ 7 ଚାଲିଛି 138 act ସେତିକି
Do it.
ଦରକାର
Just remind me and you can go. No
Madam.
problem.
Yes,
Don't do it. Don't do it. I'll do it.
Yes, madam.
No, only a simple mistake, my lord. Barampur additional session judge, the Barampur Ganjam here, Bhanjanagar Ganjam. 53 item only.
What to do?
My lord?
Oh, then again it has to be listed.
Modification file का
Kali order is.
I have already signed it. I can't change it like that. I have already signed it. If you filed wrong things, then what to do? Move an application for move an application. If I would not have signed, then what? That is a different story. I have signed it.
My lord, my.
I can't change it. Yes. Yes.
Item 11.
Adjourned.
Item 13.
May I please, your lordship? Lordship, I am in Bishio, lordship. Lordship, the matter was taken for 2 weeks, your lordship.
Adjourned.
Item 16.
Adjourned.
Item 17.
May I please? Again, the matter which are adjourning, April. And don't entertain mentioning thereof.
Your my lord,
Ideally, we should have dismissed in default, but once you dismiss in default, they move
Again,
an
you can find another
application,
case.
again the same thing. Better that if they see, the problem is they're occupying the
Yes.
people, those who are mentioning
Actually,
to get it listed, their place they are occupying.
Yes,
That's
yes.
the whole difficulty. What is to do? Honest, yes.
this is an application.
Which one? 17, okay.
17. This is an
Yes.
application filed for discharge.
Hmm.
The sections were under the Unlawful Activities Act, Criminal Law.
Your
and
discharge application is dismissed.
that was, yes.
Charge is now framed.
No, charge has not been framed. Date has been fixed to 27 February.
Okay, you tell me.
So here, my lord, since Act of Unlawful Activities Act is involved, as your lordship have already heard the matter in a identical case, my lord, prior sanction was required. Without prior sanction, and that too within a specified period of time. That is what it decided in Subhasri Panda's case, my lord. That they have not taken. That is one of the ground. The second ground is that since this involves the unlawful activities, offences, alleged offences under the unlawful activities, investigation has to be carried out by an officer not below the rank of DSP, Deputy Superintendent of Police, as per section 43C of the Unlawful Act. Initially, here in this case, for 2 months, the SI, without knowing the things, probably the law, probably he went on investigating, recorded the statement, all these things, and thereafter, after 2 months, the SDPO came. He only put his signature and never examined any.
Charge sheet is filed by the
SDPO.
He can take assistance from many.
Yes, yes.
He can
So,
take that.
since involved the prior sanction was necessary, so that is how the whole process of investigation goes, my lord. And moreover, last time as I was indicating, all these offences are scheduled offences. They has to be tried by the National Investigating Agency, my lord, under the NIA Act 2008, and has to be tried, cognizance has to be taken by the special court. So on this score, my lord, I pray that let the proceeding be stayed, let the case be decided.
Your Lordship, may I kindly turn to page 49, third para. Start from peruse the case record.
49?
Peruse the case record.
Okay.
It starts from peruse the case record.
Hmm.
So far as the ground taken by the Learned Defense Counsel regarding defective investigation is concerned, it reveals that the charge sheet has been submitted by the Utkal Ranjan Das.
That is there. That I am not impressed by that. That what about sanction?
Sanction kisi ke no such ground has been taken. That has been discussed in this application. Your Lordship may kindly let me complete the total paragraph.
That ground is not available to him because the charge sheet is laid down by the competent officer.
Yes, competent officer.
So, if a charge sheet is laid down by the competent officer, then it will be presumed that he has investigated, because while investigation, he can take assistance from his subordinate.
Subordinate, yes.
Subordinate.
Yeah.
Somebody records a statement, 161 statement, or some part of it, but ultimately the investigation is looked after by SDPO.
That's
so that
true.
part.
But the question is, the person having no jurisdiction, no authority, if he records a statement, can the SDPO or the competent authority take note of this? Is not in the capacity of supervision. He is the investigator IO.
That is a disputed fact. When this IO SDPO will be on the box, you can very well confront with him. That's
yes,
that section ground wherever.
What is saying?
Show me check.
That is ground is taken, my lord. But
where is that has been already discussed by the trial court.
Sanction, where is that?
That is why it is alleged by the prosecution that the present accused. But again I am reading. Hence, it cannot be held that this case that the investigation has not been taken off by the competent officer as per provision 43 of UAP Act. It is alleged by the prosecution that the present accused, along with some other leaders of a band CPI Mayosti organization were collecting money to the same to terrorist activities against the central government as well as the state government. In the state case, a cash of rupees 12 lakh have been allegedly seized from the possession of accused persons. J. Jagannath Rao and Chandiwala Panda, the officer of a jet, it is alleged that such money was being transported to be handed over to the present accused and other members of band CPI Mayosti organization of the above proposed. It is also alleged that after seizure of the money and arrest of the above named two accused persons, the Naxals in the locality started agitating by affixing placard demanding release of such money and the accused persons. The statement of the witnesses Kasi Vishwanath Baliyar Singh, Ganapati Behera, Sanatan Behera, Konakar Babi, Savar, B. Murali, and some other witnesses recorded under 161 CRPC clearly implicates the involvement of the present accused in the alleged offences. Taking into consideration the materials available in the case record and the position of the law stated above, I may have the considered view that that is ground for presuming that the present accused is involved in the alleged offences and that is sufficient matters for proceeding against the accused for the offence under section so and so, so and so. And hence, the accused should be put on trial according to
Recently,
petition.
there was a judgment on
Yes.
UPA.
Yes.
Justice Justice Nagappan.
And this also
Justice-
relies upon Subhasri Panda case, Lordship has stayed the proceeding. The unlawful activity. Well, what your Lordship is asking, my learned friend has either knowingly didn't answer or had not gone through the records. Whether sanction has been taken, prior sanction has been taken or not. That
Completely
is
understood what my learned senior is saying.
then answer it regarding sanction.
You just satisfy the court that you
No,
have
sanction.
taken all the points at the time of framing of charge. And this is not the stage to get the sanction. This is a stage of framing of charge. This is not a stage of taking cognizance. And cognizance cannot be taken if at all it is true that the unless until the sanction is obtained, then cognizance can be taken. You have not challenged the cognizance order. You have here the charge. Discharge petition have been rejected. Why should I go ban that? That has been clarified by this learned trial court.
What do you want to show in this?
So since the unlawful activity sections under the unlawful activities are concerned, my lord, the prior sanction is a mandatory provision of law.
Which paragraph? Sanction I have not dealt with.
No, Lordship may say last probably. While dealing with the Subhasri Panda case, my lord, Lordship has देखली बात पर सुबह पंडा केस टा इतने पर बहुत दिन
अंदर ये तो फ्रेश केस है
नहीं ये बहुत ना आउट एसमेंट प्लस सिमिलर
Now, in the absence of sanction, the cognizance order is initiated.
and why sanction is necessary, my lord? That is what is explained in Subhasri Panda. They say the punishment is capital punishment. Here, unlawful activity, somebody is found guilty.
Sanction, how do you?
Yes, that is what.
No, I am on your lordship's view. I don't, my lord, go beyond your lordship's consideration. Law always take its own course. I don't dispute that. My point is, my lord, when an application is filed, especially to discharge the accused from the charges
In
framed
the
against
application,
him.
have you taken this point?
Exactly.
But if the cognizance order itself is vitiated, and then how to proceed?
Yes.
But that has not been, when an accused has not availed the opportunity available to him, he cannot, my lord, avail the same in the course of trial, my lord. That is the principle of the, but the question is that whether this application has been filed on these 3 points, that sanction has been not been obtained, on the materials are not available to prima facie make a case, number 3, then the other grounds they have stated. But that has not been, section 43 has been taken note of.
Now, what is the fact, whether you have taken sanction or not?
But I don't know. I have to take instruction. Because
That is what I wanted to.
Yes.
I'm putting it to on when? 21st, 22nd?
Your lordship, one copy may be given so that I will verify and
copy.
Oh, this judgment, my lord, I already handed over last time.
ये केस मत इधर तो को केस
सही केस सेम जजमेंट
अपन टॉपिक पे
कथा टिके बुझन एटा फेस में एटा फेस
नो quarrel.
issue notice returnable on 22nd, 23rd for video. And Mr.
Sir,
Mahajan.
any date, maybe little after 27, I have got some personal problem.
Since I am not saying it, awaiting the instruction, therefore I am giving a short date.
22 तारीख खाली गोटे दिन मोर टिके प्रॉब्लम
22 नहले 23 देरी
हां सर
23 हाँ नो प्रॉब्लम 27 नहीं 27 ना
हाँ सर
22nd
27
huh? Mr. Maharaj seeks right to get instruction regarding time to seek instruction as to whether before taking cognizance by the court below whether sanction was obtained
in time
against the petitioner to be prosecuted under UAPA Act.
UAPA as well as in IPC also.
UAPA.
This 196 also provides sanction for section 121 of the IPC also. Both sanctions.
UAPA is important, statutory sanction.
And moreover, in this case, probably the additional district judge doesn't have the jurisdiction to proceed all these things. That is not taken, but this is a question of law. That's where I am raising. Because this is a schedule offense. Now, schedule offense can only be taken cognizance by the special court. It's not a special.
So you have lost the train by not challenging the cognizance order.
But this is a question of law. It can be raised at any time.
That's right.
In Bikramjit Singh versus State of Punjab, Supreme Court has clarified these things.
Absolutely right. You come with the judgments and all on
Judgment, yes, sir.
And a copy may be given without the
Who copy? Judgment copy.
Just now you have hand over the copy.
Extra copy out Xerox ko de de.
नहीं मतलब by hand the way अपन file.
Give one more. What? Why are you arguing? Give my copy. Give my copy. What is it?
I would put it.
Okay, next. 30.
Matter has been compromised. And I am for the informant.
Where is that compromise? Then
I am for the informant. Appearing for informant.
For that, what the parties has to be there.
Postal requisite
You
not
cannot
filed.
come.
Postal requisite not filed.
You have not filed requisites also.
I am appearing, my lord, for the informant.
Huh?
Last occasion, Lordship directed to parties to present.
Who is for a petitioner?
Petitioner for the Priyanjan Singh, my lord.
Where is he?
He has some difficulties, so that's why, my lord, take up to tomorrow.
These all these difficulties are because of the interim order. Once you get the interim order, all these techniques are employed.
Even if we require
for adjournment.
But in this case, there is no
So that
interim
is the
order.
reason I am not giving interim order for it. That is the only reason.
In this case, there is no interim order, my lord.
See, I'll tell you, yes, there is an interim order. See, these orders, this matter is pending since.
No interim order is there, my lord.
Give a date here. Give a date here.
My lord, next week, man.
Next week, you, the board permits then only.
My lord.
You got
As
a
a- as
date,
a-
you
as a
don't
lordship
reply.
please.
If it's settled, where are the parties? Without lawyer also, I could have done it.
They will be present, but because of my lord, petitioner council.
Council is not required. Call the party, I'll do it. I pass it over call on VC, you call them.
Day after tomorrow, my lord, I'll
Adjourn court. You have the luxury of taking adjournment. You bring them, I would have done it. Lawyer are not required. Settle immediately.
Next week, my lord, I'll.
Next week may not be possible. There are many matters. What to do? Yes, next.
Much obliged.
Adjourn it as per board permits. Don't. Yes, sir.
May please your lordship.
Yes.
At the outset, there is a typographical error that your lordship may permit me to correct with regard to the name of the father of the petitioner. And this is a case where your lordship has asked my friend to take instruction, the passing of the FIR. The lordship has asked my friend to take instruction whether the investigation is over by now or not. That was on 6th.
The investigation going on, my lord. The case, my lord, the
Yes.
turn to under section 436, my lord.
Let me place then.
Initial 435 is registered by other offenses, my lord, IPC, my lord.
When are you going to file charge sheet?
My lord, the late, my lord, he has not been apprehended, only one act is apprehended in the meantime, my lord. And others, this petitioner and others are absconding.
He is absconding, therefore he is taken this route.
And also find unsuitable that.
I know, and this will be rejected, will not cooperate. Was the
Here, I'm not supposed to say about the anticipatory. That is that fact. Fact is a fact.
Why don't you cooperate? So that investigation will be over.
I'm ready to cooperate, but cooperation doesn't mean putting me behind the bar.
How do you know?
My lord,
How do you know?
because the 435 offense is there.
The 430 converted to 436, my lord.
And
Rival sessions.
that is what the statement 436 again it is adding to my misery. I'm ready to 19-year boy, why he will not defy?
Oh, my lord.
Why he will
Allegations,
defy?
my lord, can see.
No, let me. The allegation I will put.
One line, my lord.
No,
So
not one
serious, my
line.
lord.
Not one line. I will place. Please, Mr. Ragat, please allow me.
Yes.
My your lordship, page 10, the second paragraph. গত 22/7/2022 তারিখ মানে before that the date of registration of FIR be noted, my lord. This is 7th November 2022. Now the second paragraph starts গত 22/7/2022 শুক্রবার প্রায় রাতি 1 ঘণ্টা সমୟରେ ଆମ ସପରିବାର ଖାଇ ପିଇ ଶୋଇଥିବା ଅବସ୍ଥାରେ ଆମ ଗୋରୁ ଗୁହାଳ ଏକ ଛଣଗତା ଆକସ୍ମିକ ଅଗ୍ନିକାଣ୍ଡ ସମସ୍ତ ଜିନିଷ ଜଳି ପୋଡ଼ି ଯାଉଥିବା ଅବସ୍ଥାରେ ଆମର ସ୍ଥାନୀୟ ପଡ଼ୋଶୀ ମାନେ ଉକ୍ତ ଅଗ୍ନିକାଣ୍ଡକୁ ଦେଖି ବଡ଼ ପାଟିରେ ଡାକ ପକାଇବାରୁ ଗ୍ରାମବାସୀ ମାନେ ଆମ ସପରିବାର ବିଛଣାରୁ ଉଠି ଇତ୍ୟାଦି ଇତ୍ୟାଦି ନିଆଁକୁ ଆୟତ୍ତ କରି ନିଆଁ ଲିଭାଇବା ପରେ ଜାଣିବାକୁ ପାଇଲୁ ଯେ ଆମ ଗୋରୁ ଗୁହାଳରେ 4 ଗୋଟି ଗାଈଙ୍କର ମଧ୍ୟରୁ 2 ଗୋଟି ଗାଈ ଅଧାପଡ଼ା ଜୀବନ ଯନ୍ତ୍ରଣାରେ ଛଟପଟ ହେଉଥିଲେ ଓ ଗୋରୁ ଗୁହାଳରେ ଥିବା ଗୋଖାଦ୍ୟ ବାଡ଼ିରେ ଥିବା ଛଣାଗତ ସମ୍ପୂର୍ଣ୍ଣ ଜଳି ପୋଡ଼ି ନଷ୍ଟ ହୋଇଥିଲା। ଅଦ୍ୟାବଧି ଆମର 2ଟି ଗୋରୁ ଚିକିତ୍ସାଧୀନ ଅଛନ୍ତି। ଲର୍ଡସିପ୍ ମାର୍କ ଇଟ୍ 3 ନଭେମ୍ବର। ଉକ୍ତ ଘଟଣାକୁ ଆମ୍ଭ ତାଳଚୁଆ ସର୍କଲରେ ଥିବା ରାଜସ୍ୱ ଇନ୍ସପେକ୍ଟର ଓ ବାଘମାରୀ ସରପଞ୍ଚ ମହୋଦୟ ତଦନ୍ତ କରିଅଛନ୍ତି। So this has been investigated by the RI and Sarpanch. This is the allegation of July 2022. Now the next limb of their allegation is ଏଥକୁ 30/9/2000 ତାରିଖ ଶୁକ୍ରବାର ରାତି 10 ଘଣ୍ଟିକା ସମୟରେ ବିକ୍ରମ ବାରିକ, this is the allegation what is they made against the present petitioner. ବୟସ 19 ବର୍ଷ, ପିତା ଇତ୍ୟାଦି ଇତ୍ୟାଦି ଆମ୍ଭ ବାସଗୃହରେ ଚତୁଃପାର୍ଶ୍ୱରେ ଥିବା ଜାଲ ବାଡ଼କୁ ଏକ ଧାରୁଆ ବ୍ଲେଡ ସାହାଯ୍ୟରେ କାଟୁଥିବା ଅବସ୍ଥାରେ କାଟି ଆସିବାକୁ ବାରି ମଧ୍ୟକୁ ବେଆଇନ ଭାବେ ପ୍ରବେଶ କରି ସାରିଥିବା ଅବସ୍ଥାରେ ମୋର ଲକ୍ଷ୍ୟ ତାଙ୍କ ଉପରେ ପଡ଼ିବାରୁ ଉପରୋକ୍ତ ବିକ୍ରମ ତାଙ୍କ ଘର ଅଭିମୁଖେ ଦୌଡ଼ି ପଳାଇ ଯିବା ପାଇଁ ଉଦ୍ୟମ କରିବାରୁ ମୁଁ ତାଙ୍କୁ ଅଟକାଇ ଗ୍ରାମବାସୀ ମାନଙ୍କୁ ବଡ଼ ପାଟିରେ ଡାକ ପକାଇବାରୁ ଗ୍ରାମବାସୀ ମାନେ ମୋ ପାଟି ଶୁଣି ଗୃହ ମୁକାମରେ ପହଞ୍ଚି ଉକ୍ତ ବେଆଇନ ପ୍ରବେଶ ସମ୍ପର୍କରେ ପଚାରିବାରୁ ବିକ୍ରମ ନିଜର ମନ୍ଦ ଉଦ୍ଦେଶ୍ୟ ପ୍ରକାଶ କରିବାକୁ ଯାଇ କହିଲା ଯେ ମୁଁ ଅମୁକ ଅମୁକ ନାଓ what he says ମୁଁ ଆଜି ବାବୁରାମ ମାନଙ୍କ ଘରେ ନିଆଁ ଲଗାଇବା ସପରିବାରକୁ ଜାଳି ପୋଡ଼ି ମାରିବା ଉଦ୍ଦେଶ୍ୟରେ ଆସିଥିଲି, but that day no incident has taken place. ଗ୍ରାମବାସୀ ମାନେ ବିକ୍ରମ ବାରିକକୁ ପୂର୍ବରୁ ଅଗ୍ନିକାଣ୍ଡ ସମ୍ପର୍କରେ ପଚାରିବାରୁ 22/7 ବିକ୍ରମ ଅଗ୍ନିକାଣ୍ଡ ସମ୍ପର୍କରେ ପଚାରିବାରୁ ବାବୁରାମ ମଣ୍ଡଳ ଗୋରୁ ଗୁହାଳରେ ଛଣ ଗଦାରେ ନିଆଁ ଲଗାଇଥିଲା ବୋଲି ଗ୍ରାମବାସୀଙ୍କ ଉପସ୍ଥିତିରେ ସ୍ୱୀକାର କଲା। This is the admission basing on which 435. This is the incident they allege of July and the second incident in September. They are
It is a kind of extrajudicial conduct.
and they are instituting the case in November. This is, and secondly, this is also
September this has happened.
My lord, September.
30th September.
30th September. They are registering the FIR 7th November. And the 436, if at all it is accepted, or 435, it is of July 2000. July reported in November, basing upon the alleged. And they say these.
But despite that, why have you not got the bail?
Why are that is our ill luck. I cannot go beyond
Now
that.
is converted to 436. And see the, my lord, the condition of the cow, my lord. The inhuman manner, my lord.
No,
Then
that's
it should not be given.
everything, but what is the allegation?
But in these applications, the investigation requires, my lord.
If it is so, then why you have not reported?
Coming here, my lord, for personal
Because your lordship may see the annexure 2. What is the reason behind?
I think this is a fit case to get immediately the bail, but unfortunately, not for a passing, but you are entitled for bail. How to get out of it? It's my view.
And
allegations are July allegation, November filed, and what is what was seen? She was cutting the gate, some jali or something, enter into when the people saw, and he ran away.
And by use of
the
a
people
blade.
caught in and obtain a confession. A confession is not admissible under the act. On the basis of this confession, the entire case starts.
And that is what one of my.
This is extrajudicial confession. That even can be taken into consideration, my lord. Not confession.
What kind of extrajudicial confession? A 19-year boy.
It is sufficient for.
Confession.
It's not a murder case. I can understand it's a murder case then.
And the weapon is a blade.
And
the second annexure 2.
What is the stage of?
Only, my lord, in the month November, my lord, the case converted to 436 and the investigation going on.
What is this judgment you have?
Judgment, my lord, this is the just prior to this incident, the very same informant implicated my father, younger father, everybody in a case. We got acquitted. We got acquitted in the month of June, 19th June. In July, the allegation made. Very same informant. Page 14 may be seen, informant namely Lakshminari.
Where is the bail order? Let us see. Where is this bail order?
Bail order of the 438. 438. Rejection. It's a downloaded copy.
He would not have filed the 482 if he would have succeeded.
Yes, ma'am.
You know that. That's the problem.
It was hard and matter was resolved, and now the order has come like this. Mr. Rogade is far more experienced than us. He invariably doing criminal matters.
I have to oppose my lord.
That is the danger. He's changed side.
Yes. जा आगे छुरी मारथला बे बेंटर मारुची हो
हाँ थाई के भी सो देखिए 122 दिन पर इतना रहे कि बाद वो खेलेगा तुम कंस्ट्रक्शन को भी देख लो.
But there is direction for surrendering, na?
Surrendering. This was also for his father. He was sent to custody for 2.5 months. That is how the bail is. And as it seems, they have alleged that the blade dhori kiri pilati postela. Ako aigya 4-6 months to minimum.
You, when are you going to file charge sheet? At least he'll get a change circumstances.
Police
for that date, and observe something.
Police has to join him as absconder.
Absconder thile charge sheet hogni na.
Otherwise,
when? See, the way out is, I'll tell you, it's my view, subject to correction. Way out is, quashing is not possible. He's entitled to bail. But the problem is this, and I have to give a change circumstances to him with a lot of observations so that we go and get it.
Yes.
That's the only thing.
Yes.
So change circumstances is the only possibility charge sheet. So therefore, I mention everything and dispose up so that you can get
in the changing circumstance.
So let us wait for changing circumstances. And ask when will you supply a changing circumstances to repeat his 430.
Take instruction.
Do it because 19-year-old boy is involved and see the situation. The parents were convicted, subjected to a trial in a particular case. They were acquitted in June, and they say July this incident had happened. November they filed the FIR.
Might be behind that manner since that case.
Maybe father may be involved, but 19-year-old boy, why should he not get bail?
No, what I have been
Take
told,
it
I am
How
not.
much time? You tell me you have to complete the investigation.
My lord,
What is
I'll
there to
explain the I1.
investigate further?
he has to
There is nothing, only 161 statement. You are relying upon extrajudicial confession.
I'll instruct the I1.
For that, why should I will keep it on next week?
March.
No, March,
No.
so that the 482 will go.
That is what 29 February. And make sure that the charge sheet is filed.
Charge sheet abscond ଦେବେ
Abscond କରନ୍ତୁ କଣ? ଆପଣ ତ extrajudicial confession ନେଇ ସାରିଛନ୍ତି ଆଉ abscond କରି file କରନ୍ତୁ so that he'll get a chance to repeat his 438. Any change in circumstances, whatever there in the merit, I can observe that so that he'll get it. That's the way out to.
Deeply obliged.
Okay.
And I may be permitted to correct the
You
question.
correct it.
And one thing of the record or not related to this case. Nowadays, charge sheets have been filed. It is kept in the court sub-inspector CSI office for months together for taking cognizance. It became a syndrome throughout Odisha. I am deeply concerned about and constrained to. And I know your lordship can at appropriate time your lordship can handle it.
We'll take care of
Backdate re kori ke 2 mas 3 mas jaye padi
I
rahuchi.
know. But now things are improving, not improving.
Expecting our whole expectation is that.
No, but police also, they have started using electronic method. There are a lot of reforms coming through. Submits that there is a typo in the cost cycle of the case. He seeks to correct it in the court. Permission is granted. He may correct the cost cycles counter side. Mr. Ragada appears for the state, submits that the investigation is at advanced stage and a report under 173 CRPC is likely to be placed. Likely to be placed before the court below. Adjourn the matter, awaiting the instruction from the Mr. Ragada on 20. You get that?
Man.
Yes.
Deeply obliged.
42. Yes. Adjourn. Yes.
Wait, please, Lord.
Yes.
Lord, this present petitioner is challenging the order of cognizance dated 22/6/2021 at Annex 3. Lord, the allegation is with respect to
48 to 294 and all. Huh?
My Lord, this present petitioner,
Where
he's
is charge sheet?
charge sheet is 4/6/2021. Cognizance order file korche, charge sheet file karne. Charge sheet mo
You have not filed.
No, my lord, I have not filed. I have not.
For the petitioner seeks time to file charge sheet. Copy of charge sheet. Time review. First week March.
My humble submission is that in the meantime, the matter has been amicably settled. I'll file the charge. Yes, my lord. It has been settled. Yes, my lord. Your lordship may kindly issue notice on this ground.
Acha.
I'll also file the copy of the charge sheet in the meantime.
Right out. Copy of charge sheet for electro. First legal counsel for the petitioner submit that the parties have settled their dispute on the state ground. He seeks intervention of this court for passing up for the criminal prosecution against his clients. Issue notice to opposite party number 2, returnable offense to short offense na kono.
Yes, my lord. House trespass and
Trespass and all na.
My lord.
Will you bring them?
If your lordship directs, I'll bring them.
When?
Any date your lordship.
Next week?
Yes, your lordship.
Parties to he submits that a joint affidavit. He would be filing a joint affidavit of petitioner and opposite party number 2, and both the parties will also appear in the court on the next date of hearing, 20th.
Great.
Bring them.
Grateful.
Meanwhile, he what charge sheet? Forget it.
Yes, my lord. That is the reason why I had not. They are.
Monsieur.
This dispute is arising between the tenant and the owner. This present petitioner, he is the tenant, and there was a case as well as a counter case.
He will vacate the house.
Well, we have already paid the rent and we have already vacated the house.
20th, you bring
Great.
online. Let them appear online.
They can also, my lord, file the counter case question.
Both
It has also been filed, but I don't have power in that, so I don't.
What is the number you give? There is a counter case.
Give the number.
Filed by the
Owner.
opposite party against the
Present petitioner.
There is a counter case filed by the petitioner against the opposite party. The opposite party has also filed passing up to the passing file karjo. Number you just give. CRMC number.
Well, I don't have the number actually. For the owner, another council has been assigned for the. I have instruction.
Number and give it.
Yes.
Go and give.
Yes. Yes.
Tag both the matter released on 20th.
Grateful.
Yes. Give it right now.
My lord.
Yes.
46.
Urgent.
49.
Urgent.
51. May I please your lordship?
Yes.
Lordship, here the informant has she has got a dispute with her husband, who happens to be my cousin brother. Lordship, I became a victim of the dispute between both the husband and wife. Lordship, all the offences, as per the allegation of offences which are made, all are less than 7 years of sentence. Lordship, absolutely there is no specific allegation against me in the affair.
No copy have been served.
You have not supplied the copy. What is the position? Charge sheet has been filed.
No, Lordship. Copy served, Lordship, for 4 months back.
এটা সিবিআই কি সিবিআই
No.
আর তাহলে আমু দেই না কপি
498A.
আমু কপি দেই না
Give a copy, then how will you assist? Issue notice. Mr. Maharaj accept notice. Counselor, the petitioner undertakes to supply copy of the petition least on first week.
52.
My lord.
52.
My lord. In this case, my lord, the petitioners have challenged the order of the Lord and SDM Bhadrak, my lord, dated 25/7/23, in rejecting their petition under section 205 CRPs.
Yes.
Here, and rejection of ground that, my lord, they have not supplied regarding the business of the petitioner number 2. Rejection order shows, my lord, has not disclosed his business, and petitioner number 2, his wife is running a ultrasound unit. Therefore, she is not a Pardhanasi lady.
Both Abbas Ranjan Raut and Dipanjali Raut.
His wife.
Both of you moved 205.
205.
Why? What is the ground? 205, not everybody can move application 205 without going court and without taking recourse to the law.
Then husband and wife both have filed this.
What is the ground?
Ground, my lord, a businessman, and there personal appearance.
Then he has to go and pay this.
Personal appearance may be dispensing with. That's why they have.
You are on bail.
No.
That's the problem.
No bail application has been also filed.
You go and take bail, then what are the offences?
30 of the PC PNDT. Section 30 of the PC and PNDT. Ultrasound unit running.
Oh, maybe ultrasound. Where is the application? 205 application. Where is that application?
Application matter that I have not annexed on. Annex 2 is the rejection order.
What are the grounds you have given?
Fifteen is the operating person. Page 15. The record reveals that offense. Second paragraph. May I please?
Quite difficult to appear. That is the ground. If you are accused, you have to appear. Everybody is having some evocation or the other. If you are accused, you have to face the consequence.
Yeah.
What is this? It is the ground. I am very busy. I will not go. So therefore, let me,
No.
That's not the ground. 30 of PC and PND are right there. I just observed that you appear and seek remedy as available to you under law. Thereafter, if necessary, you move application 317 and Legal counsel for the petitioner submits that by way of the present petition, petitioner in the present petition, petitioner has challenged the order dated 25/7/2023, whereby the application moved by the petitioners under section 205 CRPC has been rejected. The petitioners have moved the application inter alia stating that since both of them are doctors,
No.
both of them are
Running a ultrasound unit.
they are both of them are busy in their business activities, so they are not in a position to appear in the court. The said ground did not find favor with the petitioner. Hence the application was rejected. Legal counsel for the petitioner submits that submits that his client should appear before the court on or before 7th March 20 and seek remedy available to them under law, and thereafter move appropriate application under section appropriate application under section 370 205 and oblique all 317 disposed of it. Yes.
53.
Item 53. Item number 43, your lordship directed me to seek instruction. My lord, the owner has filed a CRLMC, but that has been dismissed for non-prosecution, and now he has filed an application for restoration.
That restoration application is
My lord, I'll supply the number.
Yes.
Item 53 may kindly be adjourned, my lords.
Urgent. Yes.
I am for the informant.
Urgent. Yes.
54.
54 and 55 your lordship may adjourn it. 54 and 55 your lordship.
Urgent.
I am not well, madam.
Okay. Urgent.
My lord, he is applying for adjournment, but he has not given the certificate.
Urgent.
Application.
Yes.
56.
Totally how many matters?
May I please your lordship? The lordship, 56 item. I'm appearing for the petitioner. In the present case, your lordship, we have challenged the impugned order dated 24/2023.
Yes.
The petitioner is facing his her trial under section 342, 294, 323, and 306 IPC. Lordship, I challenge the rejection of the 311 CRPC order. Petition, your lordship.
Whom do you want to recall? PW6?
PW6, your lordship, a sister of the informant.
Where is the PW6 statement? You have not filed.
We have not filed, your lordship.
How do you know whether you got the right opportunity to cross-examine or not.
Your Lordship, well, only two questions we want to.
Where is that questionnaire? Where is that application? That also you have not filed.
We'll file the questionnaire, Your
File
Lordship.
that application, 311 application, and the statement recorded insofar as 6 is concerned. You want recall of that witness? Let us see.
Yes, Your Lordship.
These two documents you file. Okay.
Your Lordship.
Then counsel for the petitioners seeks time to file additional document to substantiate his case, her case. Let me leave the matter on services.
Your Lordship.
Lordship, this is a case under section 363, 376 2IN and Your Lordship 6 of the POCSO Act. My Lord,
Your Lordship was pleased to issue notice by special messenger. Yesterday, I have already filed the requisites, but the special messenger cost could not be assessed. So that requisite may kindly be accepted and special.
In order to delay the trial, Your Lordships. This is the fag end of the trial, Your Lordships.
Malos PW
You
8 and 9.
installmentally keep on approaching for one.
Malos, that is the.
that
That is the latches of the content council, Malos.
That is the face you have chosen wrong.
But it is the IO, Malos. IO of the
whatever,
CBI.
you can't keep on dragging the trial like this.
No,
by
Malos.
moving up.
Malos, Lordship may kindly see. Order dated 226.
Where is that order?
Annexure 1, Your Lordship.
CRMC number 4401 of 2023. The council must be having the order, Your Lordships. Order dated 2012-2023. Order
PW 8 and 9 or 6
19.
and 9. What?
PW 8 and 19, Malos.
See, then
Your Lordship may kindly ask one question that at the time of examination of PW 8 and 19, when they came to High Court, PW 21 was already examined or not? So the file it was not later on
No,
discovered.
in the meantime, Malos. Malos,
lawyer is changed and a wiser lawyer is come.
No, Malos. Lawyer has not been changed, Malos. But I admit there has been latches on the conducting council, Malos. He should have examined, Malos. Because
Conducting council accused might have instructed, Your Lordships. Why you are blaming the advocate?
What?
Why you are blaming the advocate? It is on the
Yes,
instructions of the
let me submit. I'm submitting in the court.
Yes. Correct.
Thank you. During the pendency of the case, Malos of CLMC 4401, Malos, this IO came, Malos, on 26/9/2023, Malos. I have annexed the entire order sheet, Malos.
Where is it?
Annexure 1, page 10, Malos. 26/9 he came, Malos, and they sought for a time, Malos, taking the ground that the PW 8 and 19 are the petition is pending before the Honorable High Court. Hence, we need some time, Malos. They should have, Malos, I admit that they should have examined the PW 21, Malos, who is the IO in the case and the pertinent witness, Malos, and the last witness of the prosecution witness, Malos. But they have done a mistake, and thereafter they have filed on the next day, on 5/10/2023, they filed a petition under section 311, Malos. And thereafter objection was invited and it was rejected on 10/11/2023, Lordship.
Rightly rejected.
Malos. But Malos, the pertinent witness, Malos, PW 21 is an IO, Malos. Not been examined once, Malos. Cross-examined once by this present petitioner.
Where is the statement?
Pardon, Malos?
Where is the statement when he was examined?
Statement I don't have, Malos. That I don't.
That is also minimum thing. You want to recall a witness, his statement is not there.
Well,
How do I know that opportunity is given to you?
Lordship,
What are the questions you have asked?
No,
Where-
not a single question has been asked, Malos.
So let us see how you. Why should I believe you?
No, Lordship,
Unless I see it.
Lordship, kindly see page number 10, Your Lordship.
File those documents. Where is the application? 311 application.
Well, that I have not filed, Malos. Lordship, kindly have.
That is also not there. These are minimum documents.
May I file it?
Let the counsel for the you file this also. I want to see the effect of it. Let the counsel for the petitioner seeks time to file additional document to substantiate the case. Let him do so within 2 weeks, least it till March.
Well, can it be shorter date, Malos?
No, short date.
Because thereafter, Malos, there will be accused statement of.
Whatever is there, you have to face. It is your petition. You don't file document to substantiate. You take High Court proceedings are so casual.
Yes,
Why should you be given leniency?
Well, not a single question has been asked that has been reflected in the order, Malos.
Where is the statement? Where is the application under 311? What are the proposed questions?
Malos.
There are not one thing. So many things will be put to you and you have to satisfy. Everything has to be, adjourned in March.
Obliged, Your Lordships.
60, Your Lordship, may kindly see the last order.
Join कर लगी
Join कर
Last order. What is?
My lord, initially the FIR was under 294 filed by the opposite party number 2. My lord, the dispute is regarding the father and the daughter. The daughter was taken in adoption by following the procedure as per prescribed under the adoption deed, and from the district judge it was taken. Initially the FIR was 294, 323, 354A, 354C, 506, 370.
Then 294, 323, 34 drop.
No, 294, 323 and 34 was given in the charge sheet. POCSO and other allied offences under 376 were dropped.
You are the informant.
I am the father, petitioner,
Father of the
adopted father.
informant. Victim.
Father of the victim.
Informant is online, my lord.
Informant is also online.
Yes, my lord.
Compromise matter.
Compromise matter, my lord, challenging the criminal proceedings. What date may kindly fix for their appearance?
What are the offences?
307 and other offences.
Oh, 307.
Village dispute,
Okay.
both are one village.
Injury report you have filed?
No, my lord.
Get the injury report also. Fix
Yes,
it or no. Give it.
My lord, on 28th, my lord.
27.
27, my lord.
27. He says 27.
For an appearance of both.
Yes.
62.
May I please, Your Lordship. In the last day, the Honorable Court direct to file the charge sheet copy. I have applied the copy. The
Injury report?
injury report, they have not supplied the copy. As the charge sheet has not been submitted till date. Injury or submitted. The petitioner filed this case for quashing the FIR. In this regard, he filed the joint affidavit, Faisala Patra. And
where is the injury report?
injury report, no charge sheet. No charge sheet has not been. Charge sheet है ही नहीं बोली. Till then, no charge sheet has been.
What is this document?
There is a joint affidavit filed by the petitioner.
This one?
No, this is the court says that till date no charge sheet has been submitted. So
I am interested only injury report. 307 is there.
So for the
Then we stated that he
Yes,
produced the injury report.
You get the information. Where are the parties?
party, the parties in the court below, they have also filed the affidavit that they are the informant and also the injury. I have annexed in the annex number 3.
Where is the accused?
Accused outside the stage interim order has been.
Why have they have not come to this court?
Today?
Obviously, for quashing, they have to come.
In the last local order, they are personally appear. And the court,
already?
yes, the court has already give observation. No, the 9th December.
Yes.
How many years?
No, last time they did not appear.
ଲୋକ ଅଦାଲତରେ appear କରୁଥିଲେ ଲୋକ ଅଦାଲତରେ appear କରୁଥିଲେ observation ଅଛି ଆଜ୍ଞା ଜଜ
ଦେଖନ୍ତୁ injury report ଅଛି
ଯୋଉଟା ସେ ବୋର୍ଡ ପାର୍ଟି କି ନେଇ ଆସୁ ସାର୍ on that day
ଠିକ ଅଛି
short date ଗୋଟେ
20 Yes, 64. Yes.
May I please, Your Lords? The prayer for quashing of the proceeding law on the ground of that matter has already been settled on.
Yes, where are they?
My lord, I am appearing for the State Bank of India. Actually, the case is the magnitude and gravity of the case. Your lordship see how he has deposited a deed which is void because he has not taken any permission from the.
He says settlement you are opposing.
No, settle. Then that has been settled, my lord. But settlement is a providently he has obtained the loan. Thereafter, he has paid the 70 lakh against the 1 crore 51 lakhs. So that is a civil liability that is over. But however, after the bank came to know that the fraud has committed, bank has filed FIR before EOW, Economic Offence Wing. So the crime branch CID of State Odisha has taken the cognizance, investigated, and they have filed full-fledged charge sheet. Charge sheet is filed in 2021. So what he is paid that because of he has paid the amount on compromise, so the entire criminal proceedings should be quashed. But that is not the case with lordship. This is an impact on the society as a whole. Everybody will come.
So there is not settled.
Yes, settled is civil side. Civil side, you pay.
Civil side, you have paid the money.
Yeah. Paid that is not the entire amount because the property valuation is 276 crore.
I have not committed
Now the
fraud.
government is to take it.
Vendor has committed the fraud. And I have mortgaged the property. Bank has inquired and subsequently loan was sanctioned. And thereafter, after filing of the FIR at the instance of the bank, my lord, during investigation, the police officials found that the petitioner is the victim and the person who has alienated the property is the accused.
No, this is correct. This is not the correct position. What happened? Sir, my lord, in 2004, he has purchased the property from a person. He is scheduled caste, but he has stated as Janota. And both the persons have not stated. So that is why who has given the opinion in the bank at the time of mortgaging the property, they have no complicity. Police has filed stated in charge sheet, sub-register has no complicity because there is a provision that they have to declare whether in the they are what is the caste. So, but knowing fully well, he has filed a civil suit against the person in 2008 and now he has deposited in 2013 availing 1.5 crore loan from the bank. So it means there is a fraud he has committed in non-compoundable both 467, 468 and 471. You will see when the document is being forged and thereafter for the purpose of cheating he has deposited and that is 2 acres, some 7.6 or something like that property acres and valuation is 2.7 crore. Considering all bank has given the loan on 1.5 crore.
That is not the way next to the bank, Milo. You will also make a glance.
Challenging that and again you are depositing with the bank and saying that you give the loan, which is very fully, knowing fully well. So this magnitude and gravity and he contrived entirely.
1 minute. He filed a civil suit.
Civil suit challenging that.
Challenging the property which he has purchased.
Yes. That fraudulently. But how he can come thereafter to give the mortgage to the bank to avail the loan? If he has
1 minute. When did he file the suit?
Suit in, I think in 2008, Milan.
No, date give.
Yeah, I will just
Before filing the suit or after filing the suit, he mortgaged it.
After filing the suit, he has. So it means fully knowing well that he has no title because it has a void as per the rule at section 22. Thereafter, how he can come and file? And they deposit.
Have you filed any case against your vendor?
My lord, number is
vendor that so far as the power of attorney part is concerned, I have filed the suit. But during investigation of the police has inquired the matter. The police found that the vendor has committed the fraud on the ground that he has disclosed that I am the general person.
What is his case?
Case is 2008.
1 minute. Try to understand what he says. You purchase a property from X.
Yes.
That X he cheated you.
Yes, exactly.
Cheated you.
Yes.
You purchase the property. And you know that you have been cheated.
No.
Yes, sir.
1 minute. I'm trying to put it straight. You know that you have been cheated.
Yes.
By the property.
Yes.
Despite knowing that you have been cheated, you have proceeded against the person who have cheated you. Same property you have mortgaged and taken the loan.
No.
How can you take the loan like
No. That is not.
That is what he says.
No. That it was not challenged.
I can say the charge sheet also. What
If I understand,
and the government is a
it was not challenged.
I think
that vendor has.
Don't bring
the case of
minute
2018.
Yes.
fact.
2018.
1 minute. Shouting will not improve your case. If you don't have a case, then you shout more. If you have a case, you fully also you can explain. What is this case is, you have been cheated by X.
Yes.
You purchase a particular property.
Yes.
He said that I am a general person, whereas he is an SC or ST, he could not have sold the property to you.
Correct.
You purchase that property.
Yes.
And the same property, you have, without disclosing the fact that this is a ST property or SC property, you have mortgaged that to the bank and availing the loan. Now you have paid back the amount out of court settlement, you have paid back the loan amount.
Yes, yes.
Therefore, you are before this court saying that, see, I am a victim.
Yeah.
I am in between.
Right.
I purchased the property from me, he cheated me.
Yes.
I took the loan.
Yes.
Despite the fact that I paid back the loan, this case is still going on. Please watch.
Yes, exactly, exactly.
Whole case is.
Yes.
And what he is trying to say is,
Yes.
you knew that you have been
Exactly.
cheated. You know that the property doesn't have the clean title and all.
Yes.
Still, you have utilized for the purpose. So
that is the fraud
There
committed.
will be offenses.
That is the fraud committed. By that
What
time,
is your answer to that?
yes,
Simple.
by that time, my lord, I was not known whether that sale deed is
By that time, you had already filed a suit.
filed a suit. No. Filed suit.
Okay, give me 2008 when you took.
But
Yes,
sir.
give me the suit.
On the ground that,
That is
my lord,
filed in
my
17th
vendor,
2008.
my vendor,
And had
One
filed a
after,
civil-
sir, one after another. You are trying to make more complicated. Then I have to pass it. Then you don't have a case itself. Therefore, you are talking.
Sorry.
When you file the suit, let us understand. 2008
2008.
loan,
Loan is 2013 million.
2013. Just see, if you have filed a suit, your
suit-
title was doubtful. Therefore, you filed a suit in 2008.
No. That suit was filed on the ground that my vendor, after alienation of that property, he has given power of attorney to another person for transfer, my lord.
But whatever, the property itself was in cloud.
Yes.
You know that. You are litigating with XYZ.
Ah.
How the property which is already in the cloud,
Yes.
you mortgage it and took the loan?
No, by that time, my lord, I didn't
Again,
know.
that time, what that time, 2008 time, you are talking about?
No. The power of attorney, that was the subject matter in the suit, my lord, not sale deed, my lord.
Whatever, the entire property is in the cloud.
Yes. Now the dispute is, now bank has got the
How
money.
much loan you have taken?
1 crore 30 lakhs, my lord.
130.
Yes. And sometimes-
OTS amount?
70 lakhs, my lord. And during that time, my lord, I have paid substantial amount. So thereafter, matter was settled.
So with the OTS.
I'll show the order.
You have taken, what is your interest now? You have taken the money. Forget it.
Question is, my lord, if the people will come.
Technically, he might have done it. Technically, he might have done it. But you have got their money.
Money we have got.
You have entered into OTS.
My lord, there is a huge haircut. So the total dues is 1 crore 51 lakhs. And we
You have accepted the OTS.
OTS. That is true, sir.
Don't.
What we are suggesting that if the people will come, it has a social impact, my lord. Your lordship can take a view and decide. But what will happen if the people will come and deposit, and it is an impact on the society and the bank is public money and public exchequer. How if all these things will do?
What due diligence you have done?
Then we have taken 2
You believe whatever the mortgage.
No, my lord. No, my lord.
You have what is the opinion of your
lawyer has
legal
given
consultant?
two lawyers have given opinion.
Are you prosecuting them?
Yeah. We have.
Are they accused here?
They have already examined by the police. Police has said in the.
Have you made them accused?
No, we have not. We have just
So
filed.
you are officer, the lawyer, everybody.
No, because
You are unnecessary.
during the investigation, the police has already taken care and examined it and said that they in the title deed, whatever they have purchased, nowhere the caste is mentioned. So there is no fault of no complicity.
So
of
no
sub-register,
diligence is required.
no complicity of the sub-register. No complicity.
Suppose somebody say that Taj Mahal is mine and mortgage.
No.
You say since he is saying Taj Mahal is yours and give it back. And thereafter you come here and out.
That is why what I'm saying. If this is to continue, then it will have a definitely impact on the exchequer. It is a public money. People will come and defraud us, and the fraud has been perpetuated.
You allow yourself to defraud it. What to do? Show me the OTS.
The judgment.
What was the condition? OTS condition.
Page 15, my lord.
OTS. Let us see OTS.
And
You have accepted OTS. You should not have accepted OTS.
Yes.
Where is 15?
Page 15, my lord.
Technically, he might have done it, but the fact remains that he has paid the money.
Okay, I have accepted that. This is because
If that will continue, what the bank will rather I have been cheated. Pursuant to such settlement.
How much you might have paid something to the few officers to obtain this kind of loan. That you have not disclosed.
No, by that
Yes,
time,
yes.
no.
You might have given to everyone.
That is the
1 crore 30 lakh rupees loan you are taking.
yes, yes. In the
Doubtful
meantime,
property.
no. I was running.
Their officer are also involved. I know.
I was running a shop.
Sir,
Shop was closed, and by that time, my lord, I have paid some amount, and at the time of settlement, 90 lakhs some odd was there, my lord, and it was settled on 70 lakhs.
But suit has been filed for 1 crore 51 and he has paid 70 lakhs.
But you have accepted it and
Yeah, that is correct, sir.
OA was withdrawn.
OA is withdrawn on the basis of that, but bank has not withdrawn the settled AB with regard to the criminal cases. That is to continue on that basis. The compromise has been accepted.
Where is that?
That I will show you, sir. I have instantly it is not there. I will show you, sir. Not because that is when the compromise terms are there. They have stated categorically that paper is not with me. I will show you, Lord. If your lordship permits, and
then if that is the OTS condition, then you have
OTS condition is there.
OTS
Without
condition-
withdrawing.
What he says is OTS condition is insofar as the
Criminal
OA
case.
is concerned.
Right.
OA is concerned.
Yes.
That will be dropped, but the criminal case will go on.
Continue.
Yes, yes.
Continue.
You Lord, kindly appreciate one thing, my lord. If the process will go on, my lord, criminal proceeding go on, and subsequently found that the criminal court has no jurisdiction to pass an order to declare the sale deed as null and void, they will commit an offense for 468, 420 crore. But bank will not get any benefit to that effect.
Question
my
of
lord.
benefit.
Rather, my lord,
Those are not arguments.
rather, my lord, the sale deed which has been purchased by me, my lord, that has to be null and void by the civil court. And not so far as the cheating
is-
part
that
is,
remedy-
yes, as so far as
we
the
have to-
cheating part is
We
concerned.
have to only examine the only issue that you say I have settled the dispute.
Yes, sir.
The complainant is the bank.
Yes.
The bank says that we are settling the dispute insofar as the loan amount is concerned.
Loan,
Yes, we are
that is the,
withdrawing the OA.
for
But
which, my
insofar
lord,
as criminal case is concerned, it will go on. Then on merit you have to satisfy, and if you have a case.
yes, because they have not got the amount, my lord, for which, my lord, that FIR was instituted.
No,
Please,
my lord.
please.
This is
Yes. And
Because
so now they subsequently
it
say
is the
that that is
society.
a fraudulent
yes, sir.
document.
Milord,
No, no.
I will give a judgment of the Supreme Court of three judge bench. What they have said exactly the similar cases, and this three judge bench has how distinguished even if a person has paid the amount
That
and
is there. That is always there.
and when bank has made the compromise.
Where is the OTS you give? If that condition is there, then he has.
I will bring next date, Milord.
Urgent.
Reliance.
What is the position in the suit?
Suit, I have not.
Seek to
Instruction.
instruction.
Yes, yes, yes. Even if the say it is found that the sale deed is void, my lord, or fraud, my lord, bank will not getting nothing, my lord.
Bank is not getting anything, but see, the bank,
But the society.
ideally,
there.
bank officers should not have opposed.
Yes.
But they're opposing, then it has to be adjudicated.
Yes, after getting opinion, my lord, bank has disbursed the loan. my lord.
Again, third opinion.
I know, no. Wait, they might have got opinion from their panel lawyers.
Yeah.
Panel lawyers, that due diligence they have to do it.
They have inquired the matter
And,
before the
and he
revenue
is
authority.
showing one judgment. There are many other judgments that the lawyer who has given opinion, and he is also an accused.
Yes, sir.
In any case, bail is not granted to the lawyers.
Sargam.
You let them off.
No. Actually, when we have seen that if you lordship see will what we stated, they are nowhere stated in the cast Quran and they have stated they are not the scheduled caste and scheduled tribe. So what it has not been stated in the title deed. And advocates when examined and we have sought for, they said, despite that we have depended them. Because we could not find, because they have said, you see, you in the bare eyes, nowhere you can find this is a deed, where both the parties have suppressed it. And thereafter, what says their sisters are giving that property to somebody else developer. Then matter came to the knowledge to the fore, and then when by account NPA, we again investigated to an advocate. Then it is pointed out therein, and then bank has said, if you pay the money, but the criminal case will come. That is it. Yes, I will take answer.
In the file for quashing of affair, both the petitioner and petition number 1 and 2, both are now married. And here in the offense 363 of IPC, my lord is already issued notice to the informant is the mother.
Yes, my lord. I am appealing for the mother, my lord, informant.
Mother,
Yes, my lord.
where is the accused?
My lord, till date, my lord, after my lord the kidnapping, till date we have not contacted the daughter, my lord. With the daughter, my lord. After my lord the lodging of this affair, till date we have not contacted with the daughter, my lord. I have not contacted with my daughter.
Daughter is the co-petitioner with
Victim has not yet been rescued.
She is staying with she is joint petition by wife and husband.
ସେ ଝିଅ କେତେବେଳେ ଆସିନାହାନ୍ତି?
They have to appear. You can't
ଆସନ୍ତୁ।
bring them.
Yes, your lordship, direct, my lord.
Bring them tomorrow.
Lordship, give it pass over. I will telephone to International Lower Court Council whether they appear tomorrow or day after tomorrow next week.
Whenever you can come, bring so that the mother will also come. She will see at least
Yes,
daughter
yes.
and will quash it.
Yes.
What is the when? You tell me.
Lordship, just one pass over. I will telephone.
The next pass over 2 minutes after.
I'm going telephone na kari re
Huh?
List
This is the last item. Okay, you do one thing. I'm adjourning. You telephone, seek instruction,
Yes.
and intimate.
ପେସ୍କାରଙ୍କୁ ଆପଣ ଗୋଟେ
ହଁ ମୁଁ ଦେଇଦେବି ଗୋଟେ ଡେଟ୍ରେ ଦେଇଦେବି ଗୋଟେ slip.
You intimate Jyoti, he will do. Give it.
Lordship, one prayer.
Next week or 16th or 15th.
Lordship, one prayer mila. Lordship may protected, Lordship. When they appear, Lordship, protection may be granted. There is no protection.
You are coming to the court. Who will arrest you from here?
My board.
Nobody is going to arrest you. Bring her. I'll pass there and then what is the protection? Tomorrow you bring. Therefore, I'm saying Monday.
Yes.
କଲ୍ୟାଣ
Let both wife and husband come here.
Yes.
The mother-in-law will also come.
Yes.
Then they will see and quash it. Go.
Yes.
ମା ଝିଅ କଥା ହେବି କଣ କରିବା ଏପର୍ଯ୍ୟନ୍ତ ଝିଅକୁ ସେ ଦେଖି ନାହାନ୍ତି।
Because what happened is, see, the petitioner number 1 has married to petitioner number 2. They look.
My lord.
Mother-in-law, the mother of the girl, petitioner number 2, is the complainant.
Yes.
She comes and says that she is not in contact with me. Obviously, it is a habeas corpus petition in disguise.
Yes.
Intrusion.
Yes.
So both the things will be over once they appear in person.
Exactly.
Habeas corpus is
Senior Anirudh Das was mentioning that he had no objection if 205 petition will be allowed.
ଆଜି କେତେ ରିଙ୍ଗ୍?
You are informant.
He is the informant. He is the associate of the Mr. Das.
No, this is arising out of ICC case.
My lord, the 130 NI Act proceeding. My
Okay.
205 petition. He has no objection if 205 is allowed.
Okay.
And
Mr. Das appearing for the opposite party number 2 submits that he has no objection if the application moved by the petitioner under section 205 CRPC before the court below is allowed. The petition in the present petition, the order dated 5/1/2024 passed by the SDJM Talcher in connection to the ICC case number 18 of 2019, whereby
2009 lordship.
2019.
999. Long.
You are right. You have written.
I'm sorry.
What is 2009? Whereby the court below has rejected the application under 20 application of the petitioner under 205 CRPC is under challenge. Is under challenge. Since the after issuance of notice, since the opposite party has considered to the case of the petitioner, the petition is allowed, and the application, the impugn order is set aside, and the application moved by the petitioner under section 205 CRPC is allowed. Yes.
Lordship, may I fix a date for active statement, recording of active statement?
That code will do. That code will do. Yes, whatever is there.
Great. Obliging.